Item number 1.
Yes.
May I please allow me? Government advocate was directed to produce and record or email the salary sheet.
Lordship, this payslip for last 6 months. During the salary of the treasury officer only, Lordship.
Okay, we'll examine and pass orders.
Lordship.
We'll examine and pass orders.
My lord, in this regard, my lord, I just make one submission, my lord.
Yes.
Lordship will examine this question because I have, my lord, collected some observation of the Supreme Court. The mayor's salary, receipt of salary cannot cure the defects of the transfer order. And I'm just reading, my lord, I have given the compilation. My lord,
Yes,
I'm
yes.
just reading, my lord. My lord.
No, don't
It was
read. We have.
observation of the
You just give
No,
the
just-
paragraph
I'm just
numbers.
one-
Please
one-
don't read.
My lord, therefore, madam, mayor receipt of salary against the post where I was transferred cannot cure the, my lord, inherent defects of the, my lord, transfer order, because transfer has to be made against a substantive post. Transfer cannot be made against non-existent post. Therefore, it is your own stand that post is yet to be sanctioned and created and sanctioned by the government. And you are
We've taken
saying,
note of that, Mr.
My lord.
Prakash. We've taken note of that yesterday.
my
Please
lord,
don't make repetitive argument.
on the other, my lord, just one line, my lord. They are saying now, yesterday they have made a submission that the establishment
Sorry,
of
we are not. Sorry. We heard it yesterday. It is only for a document which we adjourned it.
My lord, as your lordship, please.
The
Lordship,
both sides are represented. The arguments were already concluded. Both sides are represented and heard. The Mr. Kapil Anand, senior government advocate, has produced a copy of payslip of last 6 months in respect of the petitioner. Who's lost?
this one side.
List has been.
Just if he has been paid the salary of a treasury officer,
Lordship.
right? And the treasury officer post is not created at Longding.
And basically,
Where the salary is being paid?
Basically, the post is not created against any particular area, Lordship. The post is sanctioned by the government, Lordship,
Yeah.
as per the requirement, Lordship. And once posts have been created, Lordship, employee used to be appointed and they used to be transferred at designated, Lordship, working place, Lordship. This is the concept, Lordship.
We have some difficulty in.
So here, Lordship, the substantive post is once you have been appointed against the substantive post, Lordship, you carry along with you all the benefits, Lordship. There are cases, Lordship, which has been also referred in the judgment itself, Lordship, where Lordship, the one person who was an executive engineer, he has been transferred as an OSD Lordship. OSD as such post is not there Lordship. In that context, Lordship, it has been held by this honorable court that you cannot be transferred from one to such place where there is no Lordship. That was the Lordship case. Even that has been referred in the Lordship impugned judgment, and that has been distinguished also in the impugned judgment Lordship. And this is one, I'll present one citation Lordship. Paragraph I have mentioned on the point Lordship.
Just announce that citation because otherwise Mr. Purkasa will not be knowing it.
Lordship. This is 1994 6 SCC 98 Lordship. Paragraph 24.
Okay. Mr. Purkasa, you did not give us a copy of the judgments.
Violation.
Given my local advocate, yes, my lord. My lord, she will, my lord, placed on record.
Okay.
I have relied on 4 decisions, 2 decisions already cited, and 2 more decisions. And lordship kindly appreciate that these are the stand they have not taken in affidavit. Therefore, in view of the law letter by Nasim Banu's case, that part shall be deemed to have been admitted. They did not file any affidavit. Now they are saying all this thing, my lord.
Mr. Purkasa, this is not a citation what you are giving.
No, Lord, citation already, my lord. I have handed over to a local advocate, and she will, my lord, possibly,
I
she
know
is.
this compilation is, in this compilation, there is no judgment.
There are 2 decisions, my lord, in this compilation. At page, my lord, at page 8 and 8 onwards. In addition to that, my lord, 4 decisions are already placed on record, I think, my lord. You got it this way. Otherwise, she will, my lord, place on record today itself, my lord, before the court master.
We have been given 3 judgments, one Tayabadi Ahmed, one Jumtum Tato, and one
Yes.
Sunil Shirang Bavaskar.
My lord.
3 citations have been given.
And these 2 judgments, 2 more judgments today I have in the compilation, my lord.
No, there is no judgment we have received.
No, my lord, compilation at page 8.
We don't know. Show it to Mr. Tabin if he can find out. Or you also. Please just check if there is a judgment here.
2016 SCC
We don't
online.
know, Mr. Purkasa, we don't know this.
My lord.
We don't have it.
My lord, today, my lord, today she will place, my lord, before court master.
कैसा प्लेस कर रहा है क्या ये क्या केस नाम
Okay. Both sides have provided copies of case citations on which reliance is placed. Argument is concluded. Judgment is reserved.
Item number 2.
My lord, basically this PIL, it's not against the women reservation. Rather, my lord, trying to strengthen and not strengthen the reservation system and not to dilute it, because provisions of law are there, but then state is just sitting over that without implementing. It is provided in the Article 243T of the Constitution and also in the Act. But then, my lord, maybe because of this PIL, the eyes and ear of the government may open. So, my lord, otherwise, my lord, the way it has been done, this is in this advocacy system, it may face legal consequences at the later stage. So, my lord, the basic essence of this PIL is the Article 243 and proviso to Section 53, which provides that the state legislature has to prescribe the manner of reservation. Well, in proviso 253, it provides that either by rotation or lots in the manner prescribed. But then since that manner has not been prescribed, either by rotation or by lots, so therefore, my lord, the deputy commissioner, the way he has done it, he could not have just picked the lots, because whether it will be either rotation or by lots.
You mean to say that some kind of a roster?
My lord, that is for the government to decide. That is what I am claiming, my lord. That has to be provided, and until unless that is provided, my lord, the way deputy commissioner has done it, he could not have done it.
Just trying to think aloud. When you say draw of lots, according to you, how many manner of draw of lots is available? How do we do it?
Well, that is what that is my case, my lord. Well, government has to prescribe the manner,
We understand, but you see, there is a general perception also.
my lord.
So we were just asking for the purpose of understanding. If we say draw of lots, according to you, what is the manner of draw of lots? Or number one, you
my
know
lord,
it, or you
draw-
don't know it.
Draw of lots means it will be a percentile basis, because 1/3 and one single percentile basis, because 33% has to be reserved for the woman. Now, my lord, here,
I don't know, because when I was a kid, small kid, they were, birthday, or wherever we go, we have birthday celebrations. In birthday celebrations, somebody puts the hand in the bowl, takes up a name, and then prize is announced. This is, we understand, is law of draw of lot.
yes, most probably, my lord, under 15(2), they have done it. They have kept all the,
In lottery, you have seen a lottery draw.
yes.
How does it happen?
My lord, generally,
For every number digit, there is a mechanized machine which gives a number.
my lord, ordinarily, there are 3 cycles, because 33, 99. So, if the lot is done for the first time, then 33 comes out. On the next day, next term, these 33 will be kept out, because it cannot be. So the rest is there. Out of that 66%, again, draw will be conducted, and there the 33% will be taken up. And therefore, the another 33 that is left will be reserved, then automatically will be reserved on the 3rd term. But that is how we understand, my
That
lord.
is what we understand.
Yes.
Okay,
So, my lord, here in this case, my lord, when the statute provides that the manner has to be prescribed, my lord, it has to be prescribed within the purview of the law or the act. My lord, my respectful submission here is, my lord, when the law, when the system has been prescribed, it has to be carried out on the basis of that only, my lord. My lord, I have just only one difficulty, my lord, here is our library is sort of books, and
it's
there is
okay,
no
we have
common.
it.
Yes, my lord,
We have it.
from the Nazir Ahmed case onwards, my lord, anyway, my lord, 1999, volume 3, page 422, paragraph 31 and 32. But I have the books.
1999,
3 SCC
452.
422, my lord, page
422.
422, paragraph 31 and 32, my lord. Then, my lord,
Just a moment. Please give us some time to find out.
not in this case,
Just a moment.
Supreme Court has taken back even to the Nazir Ahmed case also.
Which paragraph?
31 and 32. On the principle
Paragraph
that
31, how does paragraph 31 begin? What is the starting line?
it is the basic principle of law.
Basic principle.
Yeah, long settled that if the manner of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all.
Yes. Yes.
My lord, this has been reiterated in 2005 volume 1 also, my lord. Anyway, my lord, I have one recent Supreme Court judgment.
Article 5, volume 1, page.
Page 368, my lord, paragraph 26.
Same principles.
Same principle. My lord, recently, this is not reported in the SEC, unreportable, but then in paragraph 15, recently, 3rd March 2025. May I just read a few lines only in paragraph 15.
Yes.
Paragraph 15, my lord. Page
Yes.
5, my lord. Down below, last line.
Yes.
Apart from that, it is a settled law that when a law requires a particular thing to be done in a particular manner, it has to be done in that manner alone or not at all. My lord, under such circumstances, my lord, my respectful submission is that the Deputy Commissioner could not have adopted this ad hoc system and could not have just usurped the power of the state authorities, my lord. And having said that, my lord, I have great respect for the reservation of women in any post, since it is the provisions of the law. The statutes also provides that. So therefore, this impugned order could not stand the test of legality.
Okay.
But I think on the last occasion, David said some instructions were sought from the government.
Lordship, I have received the instruction. Before coming to the legal aspect, Lordship, I'd like to place the instruction that I have received, Lordship. Lordship, as per the constitutional intent and the intent provided under Section 53 of the Municipal Act, Lordship, there's a reservations of 33% lawsuit. Instruction is the lawsuit, so far MENA is concerned lawsuit. That has not been lawsuit prescribed as per the Act lawsuit. Prescribed has not been, MENA has not been prescribed. If I take lawsuit to the page 5 lawsuit, page 5 lawsuit,
Of this compilation.
this compilation lawsuit. This is a part of the instruction lawsuit.
You've given a copy to Mr. Patil.
Lawsuit, this is the second term lawsuit. The next election, the past election was already conducted lawsuit. This page 5 lawsuit, this is the board proceeding of past election lawsuit, past elections. This is how lawsuit at that point of time lawsuit, law 3 was drawn lawsuit. Reservation 1/3 lawsuit. During that time lawsuit, a general meeting was called lawsuit. All the corporators, MLA, all of them were lawsuit, invited lawsuit. The agenda, just to satisfy lawsuit, the page, kindly previous page list, page 4 lawsuit. Page 4. This is the agenda lawsuit that was adopted, used to be adopted lawsuit. Here the arrival and registration of participants, welcome address Deputy Commissioner, speech by the municipal elections by so and so, brief message from MLA, both two MLAs are here lawsuit. Any queries, clarification, political parties or corporations. Even clarification used to be given on the sport lawsuit. And all this used to be videograph also lawsuit. And this is the how lawsuit it used to be, it was done at that point of time lawsuit, 2020 lawsuit. And if lawsuit turn to page 6 lawsuit, page 6. This is for the mayor lawsuit. And law 3 was drawn. Here lawsuit, how they did, just I have taken instruction that is 2 male, 1 female. They 3 cheat were lawsuit put on the lawsuit that ball, and it was picked up by the public lawsuit. 2 male and 1 female lawsuit, because then it maintained the ratio lawsuit. And in past election, that's 2020 lawsuit. That time lawsuit, when law 3 was drawn lawsuit, it came for the male lawsuit. Now, kindly come to the same precedent has been followed in this year also lawsuit. And that is at page lawsuit, page 2 and 3. 2 is for the corporators and 3 is for the mayor lawsuit. Here lawsuit, this year what happened lawsuit, only 2 cheats were put lawsuit, 1 male, 1 female, because the past time already it was covered by the male lawsuit. Now to maintain ratio, this year only 2 cheats were, well, 2 tickets were put, 1 male and 2 female lawsuit. Now female was drawn lawsuit. And next year, next time what will happen lawsuit, automatically it will go to the male lawsuit. Again, this rotation, this procedure will be followed for the lawsuit. That is how lawsuit is being conducted. And if lawsuit see the page 1, this is the communications from the lawsuit director ULBs.
Please repeat again. 2020, what was the procedure?
The same procedure lawsuit. Meeting was called.
This 2020, how many people were candidates?
Lawsuit candidates, so it was lawsuit 20 seats. So far corporates are concerned lawsuit. Page 5 lawsuit. Page 5 is for the corporators. But we are not concerned with the corporate for the purpose of procedure only lawsuit. I'm just taking lawsuit to this. Out of 20 lawsuit, 7 seats has to be for the female lawsuit.
How is the 7 distributed between the wards?
It is picked up from, because Lots.
Drop lots.
Lots.
Okay.
Lots. And if Lordship turn to next page, that's page 6, Lordship. This is for the mayor. At that 2020 Lordship. Page 6 is for the mayor, which is relevant for the present case Lordship. I'm apprising this honorable court that during that time Lordship, 3 tickets were put Lordship, 2 male and 1 female to maintain the ratio. In past election, past lottery Lordship, male was
That is in 2020.
2020.
Three persons,
3 tickets.
3 tickets.
Two male, 1 female. Cheat Lordship. That was poll and it was put on. No, candidates is not on the candidate. Candidates may be Lordship. Because lottery is drawn before election Lordship. Whether it will come for the female or male.
That means draw of lots for 3 tickets.
3 tickets.
Okay.
No, 1 ticket. 1 male, is only 1 here Lordship.
Okay.
To maintain the ratio of Lordship, 1/3 women reservation Lordship, 2 male Lordship, and 1 female. 3 cheats, cheat paper were Lordship. It was written there Lordship, 2 male and 1 female, and that was put on the ball, and it was picked up by the public present there. It was videographed Lordship. And on that Lordship, lottery Lordship, it was picked up for male Lordship. This is a past election Lordship. Now to maintain ratio, this time we have put only 2 cheat Lordship. 1 male, 1 female Lordship. And this also videograph Lordship. And this time Lordship, female was picked up Lordship.
That is page number.
Page 6 Lordship.
Page 6 is 2020, this year.
Look, I'm sorry. Page Lordship 3. Third.
Page 3.
Page 3.
This methodology which you mentioned,
Lordship.
this was prescribed in
It's not prescribed. It's not prescribed. It's being followed by the deputy commissioner. As a Lordship, in past election Lordship, it was this methodology was Lordship adopted, and it's being followed this year also. Since there is no manner prescribed manner by the government as per the Act Lordship. To advance the Lordship intent of the provision, this methodology has been adopted by the deputy commissioner, and this is not in derogations of the intent and the provisions of section 53, but to advance the objective, objective of the very provision, it has been done. It may be Lordship, noted Lordship. And this year Lordship, female came Lordship, and next year, automatically it will go to the male Lordship. Again, this rotation will be.
this time 2 lots, 2 cheats were given to increase the chance of women. So that earlier, because earlier
Only male already covered one tenure Lordship.
this case is that this kind of methodology which you have adopted, this should have been prescribed,
Correct, Lord.
satisfy the requirement of manner. That is his.
Yes, that's his case. But as I submitted just now, Lordship, when it's not prescribed, it cannot defeat the Lordship, the intent of very provision, Lordship. This constitutional provision that cannot be defeated, Lordship, unless my action is against the intent of very provision. And if my action is to advance the Lordship, the intent of the provision, objective of the provision, then Lordship, that cannot be held Lordship void or illegal Lordship. That's the point what I'm pointing out, Lordship.
The manner of implementing this is not prescribed. You know, like
As per the act, is yet to be prescribed.
last time, this time 2 cheats.
2 cheats, Lordship.
It's not prescribed. Would it amount to giving unguided discretion?
No, because the manner now when it has not been done as per the prescribed manner, because manner is not prescribed Lordship. The manner adopted by the deputy commissioner, whether it's apparently it has been done in consonance with the intent of the provision or not, that has to be seen by this honorable court, Lordship. And this is the Lordship, it page 1 Lordship. There was a direction from the director ULB Lordship, directing the deputy commissioner to Lordship. I would like to read this Lordship. Paragraph page 1 Lordship, the first page. This is by the director to address the Deputy Commissioner of Capital and East Siang. I'm directed to inform you that the State Election Commission by its, letter number so and so dated so and so has intimated that the commission is contemplating to hold the general elections to the Itanagar Municipal Corporation and the Pasigat Municipal Council in the month of December 2025. In this connection, the commission has requested to reserve seats for women and issue necessary notification as per the provisions of relevant act and rules. Therefore, you are requested to reserve seats for women and issue notification as per the provisions of the act and rules and intimate the same to the State Election Commission on or before dated so and so lawsuit. In terms of this lawsuit, Deputy Commissioner, he has adopted as it was adopted by the earlier lawsuit Deputy Commissioner in the past term lawsuit. There's the one precedent is being followed lawsuit. Now I'd like to lawsuit place two citation, then rest I'll leave to this court lawsuit.
Just a moment. Please come to page 21 of the writ petition.
Type copy space 22.
It's okay.
Hello, close.
Now this page 21, post of mayor, 5-year reserved for women. Correct? Page 21,
Lawsuit.
B, post of mayor,
Lawsuit.
5-year reserved for women.
Correct lawsuit.
Now, if it is reserved for women, why this draw of lots?
So it's after draw of lots only. This communication is after the lots only lawsuit.
Oh, this is after that.
Yeah, after that lawsuit.
Oh, okay.
This is the communications lawsuit given by the EAC for the Deputy Commissioner. To the Commissioner, this is communication from the Deputy Commissioner to the government lawsuit.
After the
After the lawsuit.
Achha. Okay.
And citation to citations.
Please tell the citations to Mr. Patin also. He would otherwise not be listed.
This citation is in agreement with the lawsuit. What citation placed by my senior lawsuit?
No, whatever, but give it to him. Give the citations to him. Otherwise, no, may not be copy, but give him the citation number at least.
Oh, citation. First is 1986 4 SCC 667. Surinder Singh versus
677.
667. Second is 2018 8 SCC 24.
Malat, I have one small submission. Yes.
Lawsuit, as I've submitted, my citation is in the tune with the lawsuit. What citation has been placed by my senior? That is the provisions given has to be given effect as it has been prescribed in the lawsuit, the act itself lawsuit. Here lawsuit, the first citation just like to place that is 1986 lawsuit 4 SCC.
Yes.
I'm taking lawsuit to the paragraph 6 and 7 lawsuit. I'm directly taking to
If
the
rules are framed, then the authorities can do exercise power conferred to them. 6 and 7 is that only, I think, in this case.
here lawsuit, it says lawsuit. Until unless lawsuit, the provision itself says the provisions will not be given effect unless the rule is framed. If that clear language is not there, then substantive law cannot be held on lordship. That can be given effect to lordship. That is the lordship principle laid here, lordship. And exactly in the present case also, in the previous section 53 lordship, it doesn't say that lordship, until the rule is framed, this provision cannot be given effect to. So on this very particular point, paragraph 5 and 6 lordship. May I read all lordship?
No, not required.
Oh, okay. 6 and 7, kindly it may be noted lordship. And lordship, next is 2018-8 SCC. Paragraph 34, 37, 38, 67, 68, and 69 lordship. Here also lordship, same lordship. Until a provision itself provides that lordship,
67, can you repeat the paragraph? Sorry.
paragraph 34,
Of the second judgment. So
second judge, yes, lordship.
on please.
Yes, lordship.
Para.
34, 37, 38, 67, 68, and 69 lordship.
Thank you.
These two citation laws, it makes it clear lordship, until unless the provision itself says
In page, this page, para 34, 37, 38, 50, 67, 68, 69. What is the legal proposition?
this is the proposition lordship. The
No,
same
is it legal
proposition.
proposition? Same.
The same proposition lordship. Rather in this 2018 lordship, this 1986 citation also has been referred lordship. So this is my submission. Rest I'd like to leave this.
Yes.
And one more thing, lordship. Sorry, I'm the public interest lordship. How public interest? This is PI lordship. Who are likely to be affected lordship by this three lordship? Kindly that aspect also may be lordship consider lordship. Only few male lordship who the prospective lordship contestant. Can that be like bring another ambit of lordship definitions of public interest lordship?
Not really. I mean, what I'm saying,
Yeah,
like that the public interest could be application of the provision in a correct manner.
No, that is
No.
that
That is only fair.
that aspect is still also. Anyway, yes, sir.
My lord, as far as the reliance on the 2020 manner, my lord, my respectful submission is that at that time also, this was illegal. My lord, even right decisions by a wrong application of law or by a wrong forum, it still remains illegal, my lord. So, my lord, my respectful submission is that the manner which was adopted, if at all that was adopted in 2022, it does not have any legal bindings. Now the law is very, very clear. It is the constitutional provisions, my lord. It is not only an statute, but it is the Constitution of India, which provides that the manner has to be prescribed by the state legislature as per law. Now, that cannot be just watered down to the way the learned senior government advocate has projected, my lord. My lord, if at all that argument is accepted, my lord, there will be any done. What about the Pasigat deputy commissioner? Will he adopt as another methods? So therefore, my lord, that decision of 2020 cannot be the precedent. And here, in this case, the law provides specifically that law has to be, the manner has to be prescribed. And in this, they have clearly, in paragraph 2, they have clearly admitted, in respect to paragraph 4, the petitioner submits that without any authority of law or notification by the competent state government, the circular issued by such and such that exceeds its scope. In this matter, it is pertinent to inform that. Yeah.
Where are you reading?
This may not be communicated because it's a just I've given only annexure only laws here. This is the communications to me laws.
But it is.
It says only laws that MENA has not been prescribed. In beginning, I have already intimated, given intimation to this honor call laws that MENA has not been prescribed.
Fair. This you can remove from your covering letter is instructions to you that you can remove. Communication protected under 123.
Look, they are for laws.
No, it's okay. 123.
Yeah.
What is it? I forgot.
20, I think.
Privileged communication. No?
Yes.
No.
Privileged communication.
No, my lord.
No, just let me find out. I am forgetting. I'm also have to. So 126.
No, my lord.
Yes.
This letter has been referred to annexure 1, my lord. I think it is page 5 something. Annexure 1, my lord.
Yes.
My lord, here, this is the direction given to the deputy commissioner by the director, local urban bodies. My lord, now, my lord, here, the notification, my lord. You lordship may come to, kindly come to page 18 of my PIL. The ambit and scope of the meeting, my lord. May I read, my lord?
Yes.
Circular 22 October 2025. Whereas by letter number such and such, my lord, this is the same letter which Mr. Tapines referred to. From the director of local urban local bodies, government of AP Itanagar, it is being informed that the State Election Commission is contemplating to hold the general election to the Itanagar Municipal Corporation in the month of December 2025. In these connections, this office is being requested to reserve seats for women and issue notification as per the provisions of the relevant acts and rules. Now, therefore, in accordance with section 15, subclause 2, my lord, of the Arunachal Pradesh Municipal Corporation Act, 1/3 out of the total number of seats of councillors, corporators shall be reserved for women belonging to Arunachal Pradesh scheduled tribe. The reservation will be determined by drawing of lots at Pare Hall of DK such and such at such and such on 28. In these connections, my lord. Now, my lord, this notification is only for the corporators under the provisions of 15.2. My lord, in this entire annexures I have gone through, my lord, there is no such circular issued under section proviso to section 53, my lord. So there is no circular, there is no authority for conducting of lots for the mayor under proviso to under section 53, my lord. Now, my lord, this vests the jurisdiction of the and competence of the meeting, my lord. And the meeting that held on 28/10 could not have exceeded the scope and extent of this circular, my lord. So therefore, my lord, as I respectfully submitted, my lord, we are not against the reservation of seats for women as such, my lord. But the way to carry out that scheme has to be prescribed as per law, my lord, on the act. And not having done that, this present one could not have been done. And then the decision of 2020.
As per this act, how is the meeting called? Under this act,
My lord,
Arunachal Pradesh
yes,
uh, Municipal Corporation Act. How
Your
is it?
Lordship, I have annexed extract of 253 and 15. My lord, may I just take your Lordship to page 15? That is the act, and extract is at page 16, my lord.
Section
Section 53,
53, yes.
yes. My lord, here proviso is important, my lord. There is provisions for reservation, but proviso,
No. The question is, how is the meeting convened?
my
Who
lord,
convenes the meeting of the municipal corporation? Is it the deputy commissioner, or it is the government, or it is the this municipal corporation itself?
Mayor.
my lord, for the purpose of reservation of seats, it is being authorized to the deputy commissioner. Otherwise, deputy commissioner has no role in the functioning of the corporation, my lord. It is the corporation mayor and the councillors, they have their chief executive officer, and it is controlled by the government through urban local bodies, my lord. Department, that is a separate department in urban affairs ministry, my lord. The role of deputy commissioner is limited only to that, my lord. My another submission will be, my lord, in context to the citations referred to, my lord. My lord, the word quote unquote prescribed, manner prescribed, my lord. My lord, means the manner has to be prescribed by by rules made under the law and the act, my lord. The way deputy commissioner has chosen is not the prescribed manner, my lord. Maybe what he has done is maybe out in outer level, maybe correct, seems to be correct, but then it is not supported by law, my lord. Not, in fact, if I am not wrong, my lord, Section 2, subsection 28 of the General Clauses Act also says that prescription means, manner prescribed means it has to be prescribed by the rule as per the law and act, my lord. The government has to frame a rule, my lord. Let them decide whether it will be by, through lots or by rotation. So not having done that, the deputy commissioner could not have adopted a pattern, my lord, on its own without authorized. So my respectful submission is that since the manner has not been prescribed, whether either through rotation or through lots, there cannot be any valid reservation, my lord. Yellow copy नहीं है तुम्हारे को। ये हाँ, ये copy है। हाँ, हाँ, हाँ। दिया उसको।
Mm. No, just a little bit. Okay.
But the written instructions that was provided to Mr. Tapin, a copy also was given to us, and they have forwarded to me. I thought this was submitted before your lordships. But in that written instructions, they have clearly stated that, that there is no prescription of any manners.
Submissions of Mr. Pertinent and counsel for the petitioner, as well as Mr. Estavinda, senior government advocate. You for all the respondents. Acha, respondent number 1 and 3, and Ms. Ananjul and counsel, standing counsel for the respondent number 2 is concluded. Order reserved. You have anything to say?
Actually, the government determines the reservations. SEC is only implementing the policy. That's
No, we wanted to make our order correct. Otherwise, we write that we have heard you and not heard you. That should be an incorrect order.
conduct.
It is almost like a pro forma respondent.
No, but still, when I write in the order I have heard, I must hear that. Justice must seem to have been done.
Yes. Highly obliged, Mohan.
May
Yes.
it please your lordship. Lordship, I beg to mention item number 20. I'm for respond number 4, lordship, on behalf of this honorable. Yes. 3 weeks time may be granted, lordship, to file our affidavit.
You have informed the other side
Yes, lordship.
with consent of the other side. The land counsel for respondent number 4 pays for how much?
3 weeks time, lordship.
3 weeks time to file affidavit in the matter.
Yes.
This stuff for 3 weeks.
Obliged, lordship.
May I, Your Lordship? Your Lordship, I beg to mention item number 11, Your Lordship. I may be allowed some more time to file our affidavit, Your Lordship.
You have informed the other side.
Yes, Your Lordship.
Consent with the other side. Mr. Vaidiram and it pays for adjournment. Just to file affidavit in opposition with.
Yes, Your Lordship.
But this is 2023.
Yes, Your Lordship, which is why I'm praying for some more time, Your Lordship.
Which department?
I am for the Chief Secretary, Your Lordship. The department is Agriculture, Your Lordship.
Huh?
Agriculture Department.
Agriculture.
Yes, Your Lordship.
Okay. In the event, no affidavit is filed at least 2 days prior to the next date of listing, the Agriculture Department and the Agriculture Department shall ensure that an officer not lower than the rank of Joint Secretary.
Chief Secretary.
Well, on my part, I have received all instruction from the after law.
Oh, that's okay. The 2023 matter,
My-
rank of Joint Secretary and the Chief Secretary shall also ensure that an officer representing him shall be present in the court through video conferencing, along with and be ready with all the relevant records so as to answer the query of the court. Next, the government advocate shall transmit a copy of this order to the concerned respondents to bring the notice to the said authorities. list. Give a date after 3 weeks.
That is on 8/12.
8/12.
8/12. Well, 8 December, I have some difficulty.
Okay.
We
10th?
we on
10th?
10th fine. Alright.
Yes, I'm well. Yes, I'm well.
Yes.
I
They-
beg
they
to
say, both sides are represented. Since Mr. Tara is there, both sides are represented. So.
I beg to mention item number 14, my lord.
1-4.
1 my lord.
Yes.
Here also, my lord, with consent of other side, my lord. I am praying some more time, 3 week time, my lord, to pile up in the opposition, my lord.
This is also 1 year, more than 1 year old.
Hmm.
We can designate a few space here. Let all the officers, all the department be here. Becomes very easier. Which is the department?
Agriculture, my lord.
Agriculture.
Hmm.
Item 14. Both sides are represented. Same order, 3 weeks. Otherwise, the officer of the agriculture department, not lower than rank of joint director, joint secretary shall be present through video conferencing. Same order, yes.
But my lord, I beg to mention item number 19 also, my lord. Here, my lord, I am appearing for private respondent 3.
19, yes.
For private, I am praying 3 week time, my lord, to pile my epidemic, my lord. Opposition.
One last of.
With the consent of other side, my lord, I informed other side.
One last opportunity is granted to the private respondent to file an affidavit in the matter, during which the matter would be heard on the basis of materials available on record with no further adjournment to the private respondent for filing of affidavit. Next, the learned counsel for the private respondent shall ensure that a copy of this order is transmitted to the private respondent and a proof of service be produced on the next date of listing.
Obviously.
Your Lordship, I beg to mention item number 12.
Item
Item number 12, Your Lordship.
12.
Yes. The leading counsel in this case, Miss N. Dungan, she is having a case at District Court UPR. The matter may be listed after 4 weeks, Your Honor. Your Lordship, the interior may be extended, Your Honor. The existing interior may be extended.
Then we are granting 2 weeks. List after 2 weeks. As paid for by non-counsel for the petitioner, interim order passed earlier stands extended till the next date of listing.
Your Lordship, 4 weeks maybe, Your Lordship, because Miss Gieta is representing the government, Your Lordship.
Pardon me?
Miss Gieta is representing the government, and she has some difficulties in the first week of December, Your Lordship, which is after 4 weeks, Your Lordship.
Okay, then 4 weeks. Okay.
My lord, extremely sorry, my lord. Item number 19, my lord, the interim orders there, my lord, that may be
19.
continued. Yes, my lord.
Okay.
My learned friend has mentioned, my lord.
Okay. 19 interim order extended.
Deeply aware.
May I please, my lord? My lord, I beg to mention item number 28 on behalf of the Standing Council of Urban Local Bodies. I've taken consent from Tara sir, who is for the petitioner. Item 28, the Standing Council is for respondent number 3.
How much time?
Maybe after 4 weeks?
You file your affidavit? No.
No.
They do it by 3 weeks because otherwise it comes to the last part of December.
My lord,
3 weeks.
anytime, my lord.
Okay.
This,
Both sides are represented on the prayer made by the counsel for respondent number 3. Matter stands adjourned to enable the respondents to file affidavit in opposition to the matter. List after 3 weeks.
highly obliged, my lord.
My lord, I beg to mention item number 15 and 16, my lord. My lord, here in this case, my lord, I have not yet received Paravat's comment, my lord. 3 weeks time may be granted, my lord.
You sent them the, have you sent them an invitation card?
My lord,
It's a new norm.
My lord,
You must send them an invitation card with some sweets,
my lord,
some toppings, and then ask them to come to your office.
my lord.
Limousine service, everything must be given now.
My lord, I have to, because last time I sent, but it's, Paravich come not forthcoming. I have to send a
Hey,
reminder,
never come.
my lord. That's,
Who is an officer who has given you instructions without a reminder? Can you name one?
my lord,
No. Then they will not give.
my lord.
Who is the officer to give you instructions?
My lord, this, the entire, the Paravich comment has to be routed through, my lord, the department, and then it's to be after law betting only that.
I understand, but who is the person who will give instructions to you? Ultimately, you get instructions from whom?
My lord, it is a collective, my lord. It's
Okay.
ultimately, my lord, that,
We hope you have sufficient space in your chamber.
my lord.
We,
My lord, all official respondent, my lord.
no, what we'll do is, I think you have sufficient space in your office.
My
We'll
lord,
ask all of them to take the entire trunk file of records and go to your office. Sit down until you draft it. This is not how government should run.
my lord, that is, I understand, my
It's a
lord.
very, very wrong picture.
My lord, usually they what to do, they initiate the process and they get
Item 19,
in, my lord, 15 and 16, my lord.
15, 16.
Yes, my lord.
Okay, both sides are represented.
My lord, I am representing
Stand-
item number 16. I am petitioner for the petitioner.
So place for.
Your Lordship, I am for item number 15, Lordship.
For the 3 weeks time to file affidavit in opposition in the matter. Next para, the learned standing counsel for the education department shall send a downloaded copy of this order to the concerned respondent authorities so as to ensure that the affidavit is filed at least 2 days prior to the next date of listing. And a proof of service of intimation to the authorities shall be produced on the next date of listing,
My lord.
at least after 3 weeks.
My lord.
Happy, Your Lordship. I beg to mention item number 13, Your Lordship.
13.
Yes, I'm on behalf of RSOK, Your Lordship. I may be given 3 weeks time to file my rejoinder.
Just give this item 13. 1, 3. 18. 1, 3, 13. You see here what has happened, that the scheduled tribe certificate of the petitioner was cancelled.
Yes.
After that, the petition was filed, there is an order of stay operating. The affidavit in opposition by the last respondent was filed in 11/20/24. So you're enjoying a stay when the authorities have cancelled the APST certificate. Kindly tell us the date on by which you will file your reply.
Your Lordship, 2 weeks, Your Lordship.
No. Tell a date. There's a calendar, I think. Just check up the calendar and tell us a date. Otherwise, we'll say that the interim order shall be revisited.
Your Lordship, by 26th
By
26th of this month. Yes.
November.
Yes.
Okay. Both sides are represented. The learned counsel for the petitioner undertakes to file an affidavit reply within 26
Your Lordship, there's an interim, Your Lordship.
26 November 2025. Next by the respondent number 4. Respondent.
Lordship,
Respondent 2, 4, and 6 have not yet filed their affidavit in opposition in the matter. And no prayer seeking time has been made. So accordingly, the matter would proceed on the basis of materials available on record so far as the said respondents are concerned. Next para, list on 2/12/2025. Yes,
Lordship, my appearance may be recorded. I am for respondent number 7.
we said all sides present.
item number 1.
May I please, Lordship, your Lordship last directed the learner GA to seek instruction in this matter.
Oh, yes, I remember.
Lordship, in the notice itself, the hearing date was fixed on 10th, but then on 30th. So 29, the estate officer has to go out on medical urgency. So Lordship, he was in charge, Lordship, who had passed the order.
Where is that order? Which page? Which page is that notice?
My lord,
Notice is at which page?
Notice, Lordship, is at just
Annexure 5.
yes,
Which page is that?
my lord, may I-
16.
page
16.
yes,
No,
page
no.
30, my lord.
That is Annexure 5. Which page is that?
Page, my lord, in my writ petition is an annexure 3, page 30, my lord, 30.
30, Lordship, page 30.
No, 3010 is the impugn order.
Yes,
Where is that? Annexure 5. Just tell us the page number.
30,
5.
notice is page
Notice
30.
is page 30, Lordship.
We don't know. The order says Annexure 5. So just show me Annexure 5. Okay.
My annexure 5 is the, my lord, impugn order.
Whatever we are, once we are referring to Annexure 5 means Annexure 5, whatever it is.
Yes, it's page 32, my lord.
32.
Yes.
But it's very difficult, you see. To
So this is the
accept
impugn
this
order.
contention. You see, I'll tell you why. Can I give you a very horrible example?
Lordship.
Now you see, a constable is given charge of the officer in charge because all the senior officers are not there. So he's made in charge for one day. Now this constable has to sign a document. Do you expect he will sign as a constable if he's in charge of the inspector? He will give his seal as in charge. Why will a person who is acting as a state officer in charge will sign as executive magistrate, lower in rank?
Gazetted officer, he is also, Lordship.
No, that's okay. But you see, if I am there, it will hurt my ego. I am in charge, state officer, and I signed as a lower rank officer. It will hurt my ego.
Lordship, the matter has been taken up because the date was already given in the notice, hearing date was. But then suddenly on 29, the estate officer has to leave the station.
No, that's okay.
Yes.
In charge, we understand, but in charge, there must be some document.
Lordship, in
Can't
the
otherwise comment that I am in charge.
Lordship, in the instruction, Lordship, Lordship, in item
You see, a charge,
para 3.
you see, a charge officer will appoint an in charge. Correct.
Lordship,
So therefore, what happens is that in our judicial functioning, supposing a district judge is absent, he is a charged officer. CGM is a charged officer where if he or she has to go on leave, then they say that I will be on leave on that day, and therefore X will be acting as in charge. So it's only a charged officer who will who can give the charge to another.
then Lordship, the proper officer will, state officer will take up the matter, then Lordship, according
It has to be set aside.
Lordship is of the view that the in charge cannot take up the matter.
No, it's not my view. You tell us if you are legally wrong.
Lordship,
Can a person who's not in charge, you mean, you understand charge? For example, the head of the department, DDO or whatever you call him, he is the officer who can assign charge of one court to another or one office to another. Somebody, for example, somebody just cannot come and say that, well, I am not the Lat Mandal. I was just an assistant, and therefore the Lat Mandal has given me the charge. I have taken over. Charge can't be taken over like that. It is only the charged officer, that is the DDO of that department, who normally hand over charge of A to B, subordinate. If you are legally incorrect, tell us.
no, Lordship. On my only Lordship, humble submission is that while setting aside, Lordship may observe that setting aside of the order, Lordship, the petitioner may not continue the construction. Otherwise, they will take it as they have win the case and then they will continue the construction. These are the actual matters, Lordship, that's happening because he have demolished the existing government quarter and on that place he's building a new construction.
Under
Constructing a new
your rules of executive instructions, is a executive magistrate entitled to hand over his functions to assistant commissioner? Can it be done?
Lordship, in while on CL, while he goes on EL.
You see, under the you see, there is a rank. Always there is a rank.
Yes.
For example, a district judge would mean additional district judge.
Yes.
So we can understand he's the same rank, and therefore, matter which is pending in the court of district judge, when he's out, he can give it to the additional district judge to take up the proceedings. So we, in our jurisdiction, we know about that only. I have limited knowledge. That's why I'm asking. Under the CRPC, an extra assistant commissioner or the assistant commissioner is not equivalent to the rank of executive magistrate. Under the CRPC, it is not there. So under your state's rules of executive instructions, whether they have been assigned to be equivalent. Because definitely, you see, you will not like, I have to go out today. I want to visit the city of Itanagar. And I tell my court master that today, okay, you start here taking hearing. I am giving you the charge. It may not go well with you. I'm just asking in that context.
My lord, here in this, because a state officer has to be specifically appointed by the government, man. Under section 3 of the act.
This shows that. Yes. Which volume will get it?
Volume 8, my lord.
8. This is okay. We have it here.
Yes.
Okay.
That I'm not denying that, Lordship. I agree with that. Agree with. Under specific section there.
Section
given
3,
the
there-
power and
by
powers.
notification, one has to be appointed, madam. A
Yes.
state officer.
That is there.
Page 162. Madam.
162.
Yes.
I'm asking you because I may not know the law of the state. I may make a blunder. That's why we are asking you about the jurisdiction. I'm
section.
not very acquainted. In Assam, I can recollect. But
Just
here-
because one is an officer was an EAC or something, he cannot assume the powers of state officer unless he is appointed.
Appointed by the state government.
Yes.
Okay. Mr. P. Tapola, counsel for the petitioner, as well as Ms. G. Leonard, government advocate, appearing for the respondents. Expera, the legality of the impugn order number. What is the number? I can't read this. Page 32. What is the number?
NLG,
NLG oblique EAC oblique state dash 01 oblique 23 oblique 237. Yes. Page 32. Dated 30/10/2025. Passed by the executive magistrate, Itanagar Capital Region, on Arlogun. Is questioned in this petition filed under Article 226 of the Constitution of India. First up, by the said order, in exercise of power under section 5 within bracket 1, bracket close of the Arunachal Pradesh public premises within bracket, eviction of unauthorized occupants, bracket closed, Act, 2003, directed for maintenance of status quo, restraining all for restraining constructions, alteration or demolition to be carried out at site, for sealing of the premises immediately by the housing department, for detailed demarcation and inspection of the property, and on completion of such action, for a direction to refer the matter to the competent authority for initiation of eviction and restoration proceedings under the relevant law. Next paragraph. Actually, the premise of your writ petition is incorrect. Because once you're challenging the authority, it would be a writ of quo warranto. And then a certiorari.
Yes. You're challenging the order.
It's okay.
So,
Next paragraph. The learned counsel for the petitioner, by referring to the provision of section 3 within bracket one. One is Roman 1. 3.1 of the said 2003 Act. In the earlier, you can say hereinafter refers to 2003 Act. 3 Act has submitted that an state officer is the person authorized to is a person appointed by the government to be an state officer, and that the notice for eviction or any other action to be taken is only by the estate officer. Accordingly, comment is submitted that the executive magistrate could not have assumed power of the estate officer and passed the impugn order. Next para. The matter had been listed before the court on 10/11/2025, and the learned additional senior government advocate was directed to obtain, you don't say directed, requested to obtain instructions as to whether the officer who has passed the impugn order is an officer competent under Section 3 of the Act, 2003 Act. Next para. The learned additional senior government advocate has obtained and produced a copy of written instructions dated 12/11/2025 from the Assistant Commissioner, Naharlagun, inter alia, stating that the matter was fixed for personal hearing on 30/10/2025, however, due to sudden medical emergency in the family, the said authority had to proceed out of the state on 29/10/2025 and returned on 2/11/2025. And in his absence, the circle officer, executive magistrate, Naharlagun, was holding additional charge of the office of the Assistant Commissioner, Estate Officer, Naharlagun, and accordingly took up the impugn matter on 30/10/2025. Next para. It has further been mentioned in the said instructions that circle officer executive magistrate, being the immediate subordinate officer, is duly authorized to exercise the powers and functions of the Assistant Commissioner in his absence, as per the established administrative practice. Next part. In the considered opinion of the court, proceedings will be no, strike it out. Say, in this case in hand, the proceedings was initiated by notice dated 22/10/2025, issued under Section 4 of the 2003 Act, requiring the petitioner to show cause and to attend the office of the Assistant Commissioner, Estate Officer, Naharlagun, for a personal hearing on 30/10/2025. Therefore, in the opinion of the court, the action having been initiated under the 2003 Act, the authority to take up adjudication under the said 2003 Act would only be an estate officer duly appointed under Section 3 of the said act. Full stop. Next para. The concerned official who has been appointed as the state officer, comma, may have been also holding the charge of the office of the assistant commissioner and is holding both the posts, comma, but proceedings under the 2003 Act cannot be taken up by the same officer in his designation and authority as assistant commissioner. Full stop. As the Act provides, adjudication by an state officer, comma, notwithstanding that the officer is holding dual charge, comma, the hearing and the decision of after adjudication can only be by an state officer. Next para. Therefore, if in an administrative exigency, the charge of the office of an assistant commissioner can be held by the circle officer, would not ipso facto mean that the office of the state officer can also be performed by any officer other than the person to whom appointment has been made in exercise of by the state in exercise of power under Section 3 of the 2003 Act. Next para. Accordingly, the impugned order dated 30/10/2025, that page 32, number so and so, is found to be without jurisdiction. So accordingly, the same is set aside. Next para. At this stage, the learned additional senior government advocate has submitted that as the petitioner is carrying out construction activity, the same would be detrimental to the interest of the public, and therefore she prays that the petitioner be restrained from carrying out any construction activities till the matter is heard. Acha, in the earlier paragraph, you add this, huh? You add there. Most of the matters, having set aside the said order dated 30/10/2025, the matter is remanded back to the state officer for conducting a fresh hearing. In accordance with law, then this paragraph will come. First of, having considered the said submissions, the court is of the considered opinion that as there is a prescribed authority to pass an order deemed fit and appropriate, it would not be in the fitness of things for this court to pass any interim order restraining any construction. Because if the petitioner is aggrieved by the said order of injunction, the petitioner would be remediless and can only apply before this court for modification of the order. First of thus, this court would be taking up matters in original jurisdiction, in original jurisdiction, which the court does not have. As disputed questions of fact may arise in such determination. Next para. Accordingly, the court is inclined to direct the petitioner, who is duly represented by his learned counsel, to appear before the estate officer, Naharlagun, Itanagar Capital Circle, Naharlagun, on 29/10/2025. Oh, sorry, I'm mistaken. 26/11/2025. And by producing a certified copy of this order, wait for further orders or instructions from the said learned authority. Next para, the next para, it is provided that in the event the petitioner fails to appear on the date as appointed by this court, it would be open to the FCT to the estate officer to treat the petitioner as absent on call and proceed with the matter in accordance with law. Next para, the instructions produced by the learned additional senior government advocate is retained on record. 26.
Yes.
Date fixed for your
Yes.
appearance.
Much obliged.
Highly obliged. That's it.
Item number 2.
Challenging this impugned technical bid rejection, well, on the basis of the
First, my lord.
the
You have amended the cost title?
on the basis of the checklist, my lord.
Yes. You have amended the cost title?
I have already amended.
That is the judgment, my lord.
That's not required now.
The query made by the court.
No, it's required for me at least.
The other 10 rule 30, which was the sole proprietor firm cannot be.
Which paragraph?
Para 16, my lord.
16.
Yes. Sole proprietorship firm, my lord, it cannot sue. But when there is more than 1%, my lord, they can sue in the name of firm.
Right. 16. Okay.
My lord, I have received some instruction, my lord. That is the instruction. My lord. There was a pre-bid meeting, my lord, on 3rd of October, my lord.
That's just a one.
Yes,
Yes, my lord.
I have to start. Then you place the instruction.
Yes.
Page 5, my lord, I have corrected the cost title.
It's okay. Once you say that,
Now,
I
my lord,
don't doubt it.
well, simple, before the learned standing council submits a report, my lord, just I want to make a small point, my lord. The point is, rejection is arbitrary and mechanical for the reasons that, my lord, the rejection is based on the sheet, my lord, checklist, not on the basis of terms and condition, and special terms and condition provided in the
That is already submitted on that day.
Yeah, well, that yesterday I forgot to point out, Mr.
It's okay. You made a statement that it is not in accordance with, there's no corresponding clause in the NIT. That's
Correct. No corresponding, my lord will find at page 14 and then where they have made a mention, my lord.
14.
Page 104, my lord.
104.
The second page of the impugn order, my lord. Serial number 3 in the, after the box, my lord, observations of the board, my lord will kindly come to serial number 3 straight, my lord.
Yes.
It has found that MS so-and-so enterprises not fulfill the condition enlisted at serial number 22 of the checklist as mentioned above. As the technical bid of MS ANE enterprises is rejected. But this cannot be, my lord. At least they must act fairly, my lord. And yesterday, my lord, other day, my lord had put a specific query to the standing council, point out a particular clauses in your SBD where you require to file an affidavit. This is not there, and this particular aspect was not pointed out, my lord. So therefore, my lord, once the German of the whole foundation of the case is vitiated by the arbitrary actions of the state authorities, then entire consequential action follows, my lord. They will have to have the consequences. That much, my lord, I have to say.
Yes.
Yes, my lord, there was a minute of meeting, my lord, pre-bid meeting, my lord. In that, my lord, additional requirements were made, my lord, additional conditions, my lord. In serial number 22, my lord. This is of 3rd October 2025, my lord. It contains 2 pages, my lord. It was informed to all the bidders, my lord, of 8 blocks, my lord. This coming has 8 blocks, 8 CD blocks, my lord. So it was uniformly, my lord, applied, my lord, to all the bidders, my lord.
Once an document, I think I'm not given.
Pre-bid meeting. There was pre-bid meeting on 3rd of October 2025 and 6th October 2025, my lord. The bidders were informed, my lord. They have to submit
Nothing to do.
the required affidavit, my lord.
This is.
You'll have some difficulty in accepting this.
My lord.
You see, pre-bid meeting is of the board.
Yes,
Is the contractors present here?
they were present, my lord.
Where is it?
My lord may also, it is not here. My lord may see page 109, my lord.
109.
Of the rate petition, my lord. Yes. Serial number 1, my lord. 109, yes.
Yes.
Yes, my lord. Serial number 1, disqualification of petitioner, my lord. The board members convened pre-bid meeting on 3rd October 2025 and 6th October 2025, during which a common checklist applicable to all 8 blocks of the district was framed and duly approved by the board. As per the approved checklist, your firm did not submit the affidavit declaring that the firm has not been blacklisted by any department, which is mandatory requirement. Hence, your firm was disqualified at the stage of technical stage.
No, that's why we are asking. You see, yesterday I could not take up single bench matters because of the paucity of time, and I told the bar that there is a full court meeting.
Yes.
And I attended that full court meeting.
Right.
Now, can I say all the lawyers present here would know about the full court meeting which had happened yesterday? We did not invite you. Board meeting is there.
Right.
But you see, in a board meeting, somebody must be present to know about it. Has this been circulated to the?
As per my instruction, they had the knowledge, my lord. They have the knowledge.
I know many things, but I can't tell you here everything.
Yes, sir.
You may not like it.
Right. So, my lord, I can seek subsequent instruction, my lord. For their
You
presence.
better file an affidavit.
Yes, my lord.
Okay, file affidavit till then. नहीं है.
Yes, we can bring the attendance sheet, my lord, of the previous meeting.
Yes.
Apparently, my lord,
But
there
you
was
also
an
have to make
additional
submissions on the interim player.
interim, my lord. What happened, my lord, in the year 2024-25, my lord? For the financial year 2024-25, my lord, there was a stay from this honorable court, my lord, because of which entire Kurunkume district, my lord, could not avail the scheme of MG Narega, my lord. So we have a problem because this scheme is only for a year, my lord. So we have a problem with the stay, my lord. No stay, my lord. We are ready to dispose it as soon as possible, my lord, but no stay, my lord.
No, but if you proceed with the matter, then the represent becomes infructuous. You are applying a condition which is not there. You say that there is a board meeting.
Yes, yes.
And your authorities don't provide you the minutes where he is present.
Yes, we can produce, my lord,
No, can't
attendance
produce,
sheet,
you see, and the officers think out of the box. They are giving you an instruction.
my lord.
You say that a pre-bid
meeting.
Bid meeting.
Yes, ma'am.
So normally we understand in a pre-bid meeting, all the participants are present.
Yes, ma'am.
So there is a minimum thing which they had to send to you.
Pre-bid, my lord, pre-bid meeting, my lord, to me would amount, cannot substitute.
No, it can.
It can't. So
It can. But that would be covered by the Contract Act.
correct.
Any modification which is informed and people who are participating sign in it.
There can be deviation.
My lord, changing of rule midway is not permissible.
Yes, quite permissible.
Deviation allowed, ma'am.
Because it's a pre-bid bid. You have not even given your bid.
Correct.
Then what is the change of rule after the game is played?
My lord, central call
apply?
fields, my lord. Yes, ma'am. Central
Doesn't
call
apply.
fields. Employer has inherent authority to deviate, my lord. But if it is applied to all, my lord.
Deviate is not in your closet.
My lord.
This deviation was inside your closet. Nobody knew about it.
At their risk, my lord. They
Well,
can
for
they
one
can
week,
obtain
one
the
week,
entry at their risk, my lord.
1 week, my lord.
Because if
Kindly
tomorrow
stay
they
this-
fail, my lord,
Well, kindly stay for one.
the block should not, the people, the villagers should not suffer, my lord. Someone has to pay, my lord. Petitioner can enjoy the entry, my lord, at their own risk.
There has to be a fairness at least, transparent. That is
Because
the
someone has to pay, my lord. Tomorrow, the villagers should not suffer, my lord. We have seen in the Kurunkume district, my lord, for the financial year 24-24.
Then we ask your officer to pay a cost of something for not giving the entire instruction.
Either way, my lord, the contractor, they will carry out the work, my lord. Either the private respondent or the petitioner.
We are not on contract.
We are on execution of work, my lord.
No, but you see, Supreme Court is passing orders not to interfere.
Yes, madam.
On the ground that there would be fairness in the procedure.
Yes, madam.
Has the government said, the Supreme Court said anywhere that even if there is total unfairness, no stay can be granted?
Monte Carlo, my lord, the petitioner should carry the interim at their own risk, my lord. Monte Carlo, sir. Monte Carlo, my lord. The petitioner should carry, those who carry the interim, they should carry the also risk, my lord.
Huh.
Yes, ma'am.
So we'll provide that.
They should carry the risk.
We provide that.
Yes, ma'am. Yes.
Heard Mr. T.T. Tara and counsel for the petitioner, as well as Mr. B. Pitcher and a standing counsel for the PWD.
RDM.
PWRD.
Yes.
Appearing for all the respondents?
Yes, my lord. Respondent, except the private respondent. Respondent number 1 to 5, my lord.
Okay, respondent was 1 to 5. Next para. In brief, the case of the petitioner. Sir, just before that you say, initially when the writ petition was filed, the same was presented by Messrs. Any Yapung, YAPUNG Enterprises, represented by its proprietor. However, on a preliminary objection as to of maintainability being raised, by an order dated 11/11/2025, the court had permitted the substitution of the petitioner. Just come here. Watch up. Okay. I did not see it. So accordingly, the cost title has been amended by numbering it as page number 5, capital A. Next paragraph. In brief, the case of the petitioner is that in the name of his proprietorship firm, the petitioner had submitted a bid in respect of an IT number where is the IT number? 101. 101.
GRD, SPL, Mandrega, NIT.
NIT, page 130.
Not page 101.
Dated 24/9/2025. Most of the bid of the petitioner was rejected during technical evaluation by minutes of the board proceedings held on 24/9/2025 on the ground that the firm of the petitioner did not fulfill the conditions enlisted at serial number 22 of the checklist as mentioned
Serial number 22.
in the said minutes. Resulting in the rejection of the bid of the petitioner. Next paragraph. Apart from finding fault with the bid submitted by the other two bidders, the learned counsel for the petitioner has submitted that the point referred to in the checklist at serial number 22 does not have any corresponding clause in the bid document. And it is submitted that the bid has been rejected on the ground which was not made known to the petitioner. And accordingly, it is submitted that the rules of the game was changed after the game was played. Full stop. Next paragraph. Accordingly, the rejection of the bid of the petitioner during technical evaluation is under challenge in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. Per contract of the Learned Counsel for the PWRD.
RD, only RD.
Only RD, sir, okay. Rural Development Department has submitted that the checklist was prepared in the minutes of the pre-bid meeting held on 3rd
October, my lord.
On 3/10/2025.
Yes, no.
Then I'm mistaken. We said about the board proceedings. Board proceedings in that earlier paragraph, starting his board proceedings, that is dated 6/10/2025. Now, this pre-bid meeting is on 3/10/2025. And clause 22 of the checklist was inserted pursuant to the consensus arrived at the said minutes. Accordingly, committee submitted that the petitioners were, the petitioner was aware of the checklist, and therefore the bid submitted by the firm of the petitioner ought to have been compliant to clause 22 of the checklist. Checklist. First of, it is submitted that having not done so, the rejection of the technical bid of the petitioner is justified.
May I intervene, my lord? There was two pre-bid meeting, my lord. 6 October also. I've given 3 loose sheet, my lord. Single page, my lord. This one, single page.
Oh, acha. So before the last line, you also say that it is submitted that another pre-bid meet was convened on 6/10/2025 at 11 hours in the office of the Chamber of Deputy Director, Rural Development, SEPA, adopting and reaffirming the checklist as prepared by minutes of the pre-bid meeting held on 3/10/2025. That is accordingly submitted, such and so. It is. It is not in dispute. You say the Learned Counsel for the Rural Development Department has not disputed that the tender document does not contain clause corresponding to the requirements of row number 22 of the checklist. Which contains Description of document, requiring whether the bidders have submitted affidavit not blacklisted by any department, within bracket yes oblique no. Next paragraph. Therefore, the only issue is as to whether the petitioner had intimation regarding the checklist as prepared and the minutes of the board proceedings for technical bid held on 3/10/2025. As well as minutes of the pre-bid meeting held on 6/10/2025. Next para. In the copy of the minutes of pre-bid meeting held on 3/10/2025, produced by the Learned Standing Council for the Rural Development Department, it contains only the signatures of officials and does not show the presence of any bidder. Full stop. The second minutes of the pre-bid meeting was convened on 6/10/2025, and the bid was opened on the same date. Full stop. Accordingly, it would mean and can be presumed that the bids were submitted prior to 6/10/2025. What is the date of submitting tender?
Uh, 101.
Yes.
Last date of submission. I mean, last date. It is not provided. Bottom, you know, last date was on 6 October.
Oh, sorry.
6 October.
Hmm?
Bidding documents website to 6 October 2025, 1100 hours.
Serial number.
Serial number 7, 8, page 108.
10?
101, my lord.
101, yes.
Yeah, serial number 8, my lord. Availability of bid documents, last date 6 October.
Time up to 11.
Yes, my lord.
That is availability. Deadline of submitting bid
11 hours. No?
11 hours of 6.
Yes.
Okay. Full stop. As per the notice in writing tender issued on 24/9/2025, last date of submission of bid was up to 11 or 11:00 hours on 6/10/2025. Full stop. Therefore, this projected second pre-bid meeting minutes prepared at 11 hours, 11:00 hours, has to be read as if the second pre-bid meet was held after the last time of submission of the tender. Full stop. Even in that document, the presence of none of the bidders, including the petitioner, is recorded. And the said document only contains the signature of official authorities. Next paragraph. accordingly, prima facie appears that a criteria which is not disclosed in the bid document has been applied in the present case in hand. Next para. At this stage, the Learned Standing Council for the Rural Development Department has proposed the prayer for any interim relief on the ground that the work in question was long overdue. And if the work is not started, it will be the public who would suffer. Accordingly, referring to the case of
Central Coalfield.
no, he's referring to
Yes, Central Coalfield.
no.
Monte Carlo.
Monte Carlo, yes.
High Speed Rail Corporation. I forgot the name.
Yes.
I just forgot the name.
I have in my WhatsApp all that judgments and tender. My compilations.
I forgot the paragraph. It might be of
It's okay. It's okay.
48 something.
There are two. That's why we are asking you this Monte Carlo. We open it up because one is Monte Carlo, which is NTPC.
Yes.
Another is High Speed Rail Corporation versus Monte Carlo.
Madam.
I think you are referring to the second
Yes,
one.
the second one. Yes, madam. 2018, I think it is of 2018. Madam.
18.
Probably, yes, madam.
No, there's no 18.
Monte Carlo, I think it's not 2018.
18 or 16, madam.
Monte Carlo is 2021. 2022.
Madam.
Cited the case of High Speed National High Speed Rail Corporation Limited versus Monte Carlo MONTECARLO Limited. Within bracket 2022, bracket goes 6 SCC 401.
That Monte Carlo versus NTPC is reported in 2016, 15.
That is 16.
Yes, 2016, 15 SCC, page 272.
Are you referring to that?
My lord,
This is,
look it from him.
I have taken out from my blue book, Malan, which is a digital. This is Monte Carlo, which you are referring.
It's good. You keep a blue book, we keep a black
I
book.
can get the hard copy, my lord, from him. I can.
Then
I maintain a black book.
Central Coalfield versus.
No, that is NTPC is different.
On
It's not
deviation.
Monte Carlo.
There is on deviation. Central Coalfield is on deviation, my lord. Employer
You are
can
relying on
deviate
which case?
Yes.
It deviate, but it should be in consonance with the SBD.
No, but you're relying on which one?
Monte Carlo, my lord.
Monte Carlo.
On interim, my lord. Only on interim.
No, you see, I won't remember the entire judgment.
Yes, my lord.
You have to tell me it is
If I
Monte
can get
Carlo
the hard copy, my
NTPC.
lord, from here, my lord. From the bench, my lord.
I
You
have
can see that?
101 judgment in this, my lord.
You can
I'll just try to help.
you can give him 2022 6 SCC 401. 2022 6 SCC 401. Show it to him if you have the book. It's okay, just leave that gap. Huh? Just mention it, but we can change
Yes.
that. To submit that in the event any interim order is passed, the petitioner should be put to risk and cost. Nonetheless, he also opposes the prayer, any prayer for interim relief.
नीचे में यहाँ से लिखता है गवर्नमेंट कॉन्ट्रैक्ट नर्सिस यहाँ से देखो
401
401
Next para. As the issue only relates as to whether the petitioner was put to notice of the clauses appearing in the checklist at row number 22. And though the authorities in the Rural Development Department are relying on the minutes of the pre-bid meeting held on 3/10/2025 by projecting as if the petitioner was present in the pre-bid meet, whereas the document does not reflect so. Comma, the court is of the prima facie view that the invocation of the clause corresponding to row number 22 is outside the scope of the bid documents. Post accordingly, comma, the court is inclined to suspend the operation of the minutes of the pre-bid and meetings of the
You don't have place.
minutes of the both proceedings dated 16/10/2025, by which the technical by which the bid of the petitioner was rejected during technical evaluation. Full stop. Next para. In view of the nature of instructions produced, which does not show the presence of the petitioner in the pre-bid meeting, or that he was served with any notice to be present in the pre-bid meet. At this stage, the court is disinclined to put the petitioner to risk as to cost. Next para. Nonetheless, a notice is issued to the petitioner as to why the petitioner should not be put to risk as to cost which may occur for the delay in the execution of the works, and why appropriate security should not be directed to be furnished in terms of the order that would be passed on the next date of listing. Next para. As the state expresses urgency in the matter, list in the admission column on 29/10/2025.
My Lord, 29, I'm attending the felicitation program of new Chief Justice of India.
Okay, then 31st.
My Lord, I'll come back on 1st. If my Lord can kindly accommodate me on 4th.
Then 3rd.
3rd? Fine, my Lord.
My lord, paragraph 48. I was right.
No, which one? That's same.
Yes, National High Street Railway.
Okay. Growing old, can't remember everything.
Yes.
But thanks for this.
My lord.
Yes, the notice.
We are
correct.
We have put you to notice.
No, no worries, my Lord. The ground which they have taken, I have found out the solution from the Reliance Energy, my Lord.
Just okay, whatever you do, we leave something for the next date also.
Yes, grateful. My Lord.
It is found that they were present, my lord, in the previous meeting, my lord.
Shall we agree to
Yes,
notice?
yes. Right.
Item number 3.
My lord.
Yes.
My lord,
Yes, Mr. Lampu.
yes, my lord. In this petition, my lord, the petitioners are challenging the action of the respondent number one.
Just a moment.
Yes.
Give me 1 minute. Yes.
Yes, my lord, in this petition, my lord, petitioner is challenging the action of the respondent number one, my lord, for cancellation of the selection process, my lord.
Cancellation of the
Selection process, my lord.
selection process.
Yes, my lord. Selection process, my lord, without having any, my lord, valid reason, without having any valid reason, my lord, or sufficient ground, my lord. My lord, may I take your lordship to the first advertisement, my lord. Advertisement at page 23, my lord.
But Mr. Lampu,
Yes, my lord.
assuming that they are absolutely wrong in the manner which they have done,
My lord.
but can a mandamus be issued that you hold recruitment test?
My lord, the selection process is gone up to the level of preliminary examination. Result was declared, and thereafter this written examination main was fixed, my lord. Thereafter, my lord, they hold this further process for 2 years, my lord. After that, my lord, what happened, my lord? Recently, by this impugn notification, my lord, which is at page 51, my lord, they have cancelled the interest selection process, my lord, without having any valid reason, my lord. My lord, there must be some sufficient ground, my lord, or a reason, my lord. Because, my lord,
No, that's why we are asking you this question.
yes, my lord.
Can we issue a mandamus to hold
Yes.
the selection process?
Yes, my lord. Yes, my lord.
Okay.
My lord, there are cases, my lord.
Okay.
My lord, first, my lord, I would take to the advertisement, my lord. Before coming to the impugn order, my lord, advertisement, my lord, is page 23, my lord.
Page
23, 23.
you're for which the post?
This is for the finance and account officer, my lord.
Finance and accounts officer.
Yes, my lord. Serial number 1 in impugn notification, my lord.
Yes.
Yes, my lord. Page 23 is the advertisement, my lord. 23, my lord. 23. My lord, this is the advertisement, my lord.
Yes.
Dated 25th March 2021, my lord. My lord, by this advertisement, my lord, application is invited from the, my lord, aspiring candidates, my lord, for filling up of 2 posts, my lord. Kindly note, my lord, only 2 posts of finance and account officer, my lord.
No, you see, this
Yes,
thing,
ma'am.
Mr. Lampu, is not under dispute.
Yes, my lord. My lord,
Whatever
yeah,
be the nature of advertisement, whatever be that call,
my lord.
you are agreed by the cancellation.
Yes, my lord.
So
My
that
lord,
is page 51.
Yes, my lord. Page 51 is the cancellation, my lord. My lord, in the impugn cancellation order, my lord, if my lord goes to the impugn cancellation order, my lord, there is no any reason, my lord, why this selection process has been cancelled, my lord. My lord knows, my lord. For cancellation of, my lord, the respondent can, my lord, cancel the selection process, my lord. They have, my lord, power, my lord. But, my lord, such cancellation should be, my lord, founded on, my lord, reasonable and valid grounds, my lord. There, it must be a sufficient, my lord. You can't, my lord, cancel the selection process without having any reason, my lord. That, my lord, knows, my lord. My lord, this is my prime, my lord, submission, my lord. Other than the facts, my lord.
Yes.
My lord, this in impugn notification, my lord. This page number 51, my lord. This serial number 1 is which was been, my lord, cancelled, my lord. And my lord, here, my lord, nothing, my lord, in this impugn notification, nothing has been given, my lord. Why this selection process has been, my lord, cancelled? And apart from that, my lord, there is 2 posts, my lord, was advertised. And out of that 2 posts, my lord, Altogether, 2,097 candidates have been applied, and my lord, participated in the preliminary examination, my lord. After that, my lord, on the basis of their performance in preliminary examination, my lord, only 24 candidates has been shortlisted, my lord, for the men's exam, my lord, qualified for the men's exam.
Yes.
Take your lordship to that. The number of candidates which has been, my lord, participated in this selection process, my lord. That is at page 28, my lord.
Page number?
Page 28, my lord. This is the shortlisted candidates, my lord, who are qualified to appear in preliminary.
So those backgrounds are
Yes,
not
yes, yes.
necessary in this writ petition. We are not
Yes, ma'am.
hearing the matter in merit.
Yes, my lord.
You have said that this was cancelled. You are agree with that.
Yes, my lord.
So what business do you have to look into the past?
Yes, my lord.
You say that you are a candidate.
Yes, my lord.
We accept your statement. You're not disputing it.
My lord. My lord, the only, my lord, so what I'm trying to apprise this honorable court is that, my lord, out of, my lord, there is only 2 posts, my lord, and out of that 2,097 candidates appear, my lord. And my lord, it is our hard work, my lord. We are find our places in this preliminary result notification, my lord. May I place one judgment, my lord, if your lordship permits? My lord, say if your lordship come to page 51, my lord, one reference is only given, my lord, as in pursuance, this is page 51, 16 October 25, my lord, which is the impugn, my lord. There is no any reason is given, my lord. Only one, my lord, the reference is given, my lord. As regard to one, my lord, the order issued by the Department of Administrative Reform, my lord. That has been, my lord, enclosed in annex, my lord, 9 is at page 55, my lord. My lord, only page 55. Only one, my lord, in this notification, my lord.
Yes.
One time age relaxation has been given, my lord.
Yes.
But that cannot be, in my humble submission, my lord. One time age relaxation has been given for those examination which has been either cancelled or which will be cancelled during, my lord, period. My lord, what happened, my lord, in the year 2021, my lord? My lord, some sort, my lord, in the examination of assistant engineer civil, my lord, there is allegation of paper leakage. And because of that, my lord, the examination which was conducted during that period has been kept in abeyance, my lord. But in the thereafter, my lord, some inquiry has been also conducted, and some examination has been also, my lord, cancelled, my lord. But this examination related to the finance and account, my lord, that has been never cancelled, my lord. And my lord, the petitioner are under legitimate expectation that, but after, my lord, this fiasco is over, my lord, their written examination will be, my lord, conducted by the commission in due course of time. But by the impugn notification, my lord, they have cancelled the selection process, and there is no any reason, my lord. Other than that, my lord, one time as a selection, there is no any reason in such. My lord, there is no any, my lord, question of fraud, malpractice, or, my lord,
You see,
yes, my lord.
Please come to page 23 that you were showing.
Yes, my lord. It's 23, my lord.
This is the examination?
Yes, my lord.
2021,
My lord.
correct?
Yes, my lord.
Advertisement is dated 25/3/2021.
My lord.
Correct?
My lord.
Now please come to page 55 you were showing, correct? In
My lord.
55, there is a reference to annexure 1 at serial number 1. Page 55, serial number 1.
My lord.
There's a reference to annexure 1.
My lord.
Annexure 1 is next page,
Yes, my lord.
serial number 2. So there's a government notification cancelling this.
My lord.
And you are yourself saying that in 2021, in the examination, many anomalies happened.
My lord, in this, not in this
You're
examination.
not saying that.
Yes, my lord.
I'm only placing things.
Yes, my lord.
I'm not forming an opinion.
Yes, my lord.
So what is wrong with this notification cancelling it? Because then now this is a gazette notification. The governor is pleased to do that. And fresh vacancy would be notified.
My lord, kindly come page 55, my lord. And one time age relaxation has been given, my lord.
No. This is an gazette
Yes, ma'am.
notification with regard to the cancellation.
No, my lord. May I read, my lord?
Yes, read number 1.
Yes.
We have read it. That's why unless I read it, I would have not known this.
Page 55, kindly, my lord.
55.
In exercise of the powers compared by proviso to Article 309 of the Constitution of India, the Governor of Andhra Pradesh is pleased to relax the prescribed upper age limit for direct recruitment issued by notification on such and such dated 25th to 2023 and to grant one-time relaxation of upper age limit for direct recruitment to all general categories born on or after 1/1/1989 and the Arunachal Pradesh Scheduled Tribe candidates born on or after 1/1/1984, enabling them to eligible and to apply for those category of posts where the previous vacancy notification issued prior to 2024, detail of which are annex is Annex 1, has been
Cancelled.
oblique will be cancelled.
So therefore, the government says
Yes, my lord.
that though we are there will be age relaxation for those candidates who have applied and whose examination is being cancelled by the Annexure A.
And my lord,
So Annexure, they have given you protection.
my lord,
Age protection is given. You'll have to do is spend some time in purchasing a new pencil and then write it, give the examination.
my lord, kindly appreciate, my lord. My lord, in the beginning I have said, my lord, there is only 2 posts of account. Out of the 2097 candidates has been, my lord, participated, my lord. It's my lord, sheer hard work and dedication, my lord. We are, my lord, eligible to participate in mains, my lord. Only 24 candidates have been, my lord, qualified to appear in the mains examination, my lord. My lord, can it be, my lord, taken away, my lord, by relaxing and age, my lord? My lord, at that time, I am, my lord, I may be quite young, my lord. But this, my lord, after 4 years, it has been, my lord, it will be real prize, my lord. After 4 years, my lord, I will submit, my lord, this is not sufficient ground, my lord, for the cancellation of interest selection process in my humble submission, my lord.
Okay. Yes.
My lord.
What does Additional Advocate General has to say now?
My lord, let me
Please,
take your lordship straight to my advertisement.
Mr. Rampu is right on one thing.
My lord.
Today somebody gives a examination. Maybe
Fresh mind.
yes, fresh graduate,
Fresh
mind.
graduate, my lord, yes.
After 4 years, I may not be so sharp
my lord.
to pass the examination again. He has a point.
But
now what do you have to say?
my lord, my only answer to the query, my lord, practice makes man perfect, my lord. My lord, he'll be getting, he has been practicing for last 4 years, my lord. Definitely he'll do better than the fresh, my lord.
No. Yes, I'm sorry. I accept that. The reason is practicing which field?
Practicing, my lord, he's preparing for the examination, my lord.
No, that's a preparatory note. One may become dull. You ask me to read. You see, Mr. Nawam, you may not know. In the work which I am doing, every order has to be revised 3 times.
But
I will tell you, I'm not yet over.
But
you see, in the first revision which I can do, I can catch some mistakes which has occurred in the order. Second correction and the third correction, I don't even see my mistakes.
But one thing, don't your lordship may kindly note, my lord, day by day, is there any improvement, my lord? Obviously, my lord.
No, that is
The better work of quality, my lord.
There are two difference in two perspectives. Number one, when you say that whether I have improved at the bench, that is not the question you are asking. We are at the stage of asking a question whether a revision which can be done twice or thrice. You see, I can assure you, if I read every writ petition thoroughly, I can find out every mistakes in each and every writ petition.
Yes, possible.
Either grammatical or something.
Something, yes.
So that is something where I goes and catches it. When I am showing Mr. Lampu this page on which we are referring, page 51.
51, my lord.
No, not 51. This
55, my lord.
55.
55.
So that is because it is fresh, I can recollect. But after some time, if you ask me that which page it was, I will forget. So it's not a question of, it's an application of mine. And a student who is not, you see, you can ask a chartered accountant, where you are daily doing the bookkeeping, you are good in arithmetic. Yes, he'll be good in arithmetic. But the same problem you give him to revise twice or thrice. If there is a mistake, it will not be pointed out to him. He'll
My
not
lord,
see that.
I may agree to that. In the one glance, my lord, it's very difficult to remember. But if you constantly turn on the same page, my lord, possibility, my lord, remember will be there, my lord.
Then try giving an examination. Try giving an examination. That will test your theory. Because you see, as a student, every day you don't prepare question papers. That okay, next year I'll be sitting in an examination. Therefore, I take that answer question key and answer key and write the answers daily. We are not on that. But a student to be smart enough after 4 years of layoff, very, very difficult.
My lord, but there are other subjects, my lord, where they have to be, my lord. The subject which they are preferring, suppose my friend is a graduate in commerce, in APCS, my lord, commerce will only be the only subject. There will be other subjects too, my lord.
Correct.
Obviously, my lord. Anyway, my lord, coming to my lord, this impugn order. Your lordship may kindly note, this impugn order, the public services issued, my lord, but in person to notification issued by the Department of Administrative Reform, which is not under challenge, my lord, in this writ petition, my lord. The government has decided, my lord, and it was, my lord, sent to the Public Service Commission to notify the cancellation, my lord. This is not under, my lord, challenge, my lord, number one. And number two is, my lord, the finance and accounts is not only the post, my lord. If your lordship say there are 14 posts, my lord. This is the second phase. First phase, my lord, we have done, my lord, for the engineers and others, my lord, because of, my lord, paper leakage, my lord. There was, my lord, huge crime, my lord, in that case, my lord. So, my lord, this is not the, my lord, first instance, my lord. This is the second time, my lord. Now, what happened, my lord? Entire system was changed, my lord. Right from the commission member, chairman, secretary, everything, my lord. Now, new team has come up, my lord. Now, your lordship has rightly pointed out the page 55, my lord. And there is a communication from the, my lord, Public Service Commission. Obviously, my sisters will be referring, my lord, that these, my lord, issues, the paper leakage, my lord, still is under investigation. It's not yet completed, my lord. The paper leakage, my lord. It's still going on because, my lord,
even after 5 years,
my lord, must be finishing only one.
A good
The last
investigating team.
I think last communication they have received from the Vigilance Department. This is, yes, 22nd July, June, sorry, 2025, my lord. So almost, my lord, they are going to complete the, my lord. Well, it's not only, my lord, for the, my lord, engineers, others also, my lord. Your lordship see the, my lord, magnitude of the applicants, my lord.
We don't know, my lord, who got, my lord, this paper and how they got it, my lord. This requires, my lord, detailed inquiry, my lord. Now, ultimately, my lord, the government decided for greater public interest, my lord. So, to go for a fresh, my lord, advertisement, my lord. So that is the best option, my lord. And here is the case, my lord, the process was not completed, my lord. Admittedly, my lord, they have given the, my lord, written examination, preliminary examination, my lord. No doubt about that, my lord. Qualified is all right. Obviously, if someone will qualify, obviously, my lord, if they have given the preliminary examination, my lord, obviously, my lord.
Mr. Nagam,
Now,
we'll continue after lunch.
my lord, yes, sure.
But before rising, I can tell you, I had the opportunity of preparing some question papers for some examinations here and there. Correct.
My lord.
But I can assure you that even after having prepared the question paper, I would not get 100 marks.
Especially in literature, my lord, is very
No, not
difficult.
that. I have prepared the question paper. Even if I sit in that examination, I'll not get 100 marks.
My lord, that happens to Charlie Chaplin also, my lord. He acted himself, but my lord, he was not qualified, my lord. That happens, my lord.
So that's the point. That's exactly the point.
My lord.
Why examination should be taken so lightly?
So, my lord, I will not repeat that Charlie Chaplin history, my lord. My lord.
I just wanted to tell the bar, with your permission, I'll rise a bit early today.
Okay.
There's a program in your bar.
Correct, my lord.
So, 3:50 I'll have to rise.
In this case, or your lordship may simply issue the notice, or my lord.
No, on merit, what you.
Merit, my lord, as your lordship ever, my lord, unless, my lord, they are offered with a letter or something appointment, my lord. Just the process is not yet completed. This recruitment process, my lord. Now, in the midst, my lord, because of, my lord, that paper leakage, that great, my lord, public service fiasco, my lord, entire system was changed, my lord. Even the members were, my lord, either they resigned voluntarily or we terminated them, my lord. When the secretaries, everything, my lord. Now, after that, my lord, FIR was lodged. The SIC looking into the broader sense, my lord, since justice has to be done, my lord, not a single innocent should be victimized. So that's how it's taking a time, my lord. So in this case, my lord, since per se, my lord, they don't have any legal right to, my lord, claim that they should be, my lord, given any relief, other in any form, my lord, since the process is not yet completed. And because of, my lord, that paper leakage, even, my lord, we, the state, even the agency, they doubt, my lord, we don't know, my lord, how many people they got this information, my lord. That is my submission, my lord.
Yes. You see, you have heard Mr. Navam.
Yes, my lord.
With his submission, your writ petition would be dismissed. So you have two choices. Number one, you can withdraw this with liberty to challenge that government order at page 55. In this form, the present writ petition can't survive. It has to be dismissed. The government order to cancel it, the EPSC is bound to act as per the advice of the government. There's no choice.
My lord, page 55, my lord.
No, you see, we are just you see, please don't take it that it's not the advice of the court.
My lord.
It is, we are saying that as per his submissions.
My lord.
This would be the logical answer. We are not asking you to do this or do that.
My lord.
It's not the court to advise.
My lord.
I'm just putting you to notice that with what Mr. Naram said for non-challenging of page 55.
51, my lord.
55. Page 55.
No, 55.
I'm sorry, 55.
My lord, this page 55, my lord. My lord, if my lord goes to this page 55, my lord.
Yes.
My lord, it's simply, my lord, in my humble service, my lord, it's simply giving giving age relaxation only. And cancellation is up to the commission, my lord, in my humble submission. only relaxation has been given because, my lord, age relaxation cannot be done by the commission, my lord. My lord, in my humble submission, my lord, this is only, my lord, age relaxation, my lord.
Okay. Mr. H. Lampul, Learned Counsel for the petitioner, as well as Mr. R. H. Nabam, Learned Additional Advocate General for the
My lord, otherwise, my lord, if my lord is dismissing this writ petition.
No, I don't know what I'm doing.
Yes, my lord.
I'll be working first and then decide, then think what the result is.
My lord, otherwise, my lord, this page 55, my lord. My lord, if this is in the humble opinion of the court, my lord, it's necessary to challenge this order, my lord. I will, my lord, withdraw in liberty, so spray liberty to challenge this. I will phrase, my lord.
Okay. Very good. For the petitioners, Mr. R. H. Nabam, Learned Additional Advocate General.
Correspondent 2 and 3, my lord.
For respondent numbers 2 and 3.
2 and 3.
Before that, Ms. N. Anjul, and standing also for the respondent number 1. Next para. The learned counsel for the petitioners praise leave of the court to withdraw this writ petition and to approach the court again to include challenge to the notification dated 21/4/2025. Next para, prayer is allowed. The matter is dismissed on withdrawal with liberty as put for.
Item number 4.
May I please, my lord?
Yes.
My lord, this writ petition is challenging the impugn order dated 19/11/2009, suspension order, my lord. Subsequent order, my lord, 18/12/24, the impugn termination order, removal from the service of the petitioner, my lord. My lord, before I take to lordship to the impugn order, my lord, I'll just apprise the brief fact of the case, my lord. Here in the case, my lord, petitioner, he was serving as a constable in Arunachal Pradesh Police, and he was posted in the PHQ Itanagar security cell. So during that period of time, there was a FIR. FIR was launched by one Nilang Tatak, my lord, by alleging of the rape of the minors, his minor sister. So thereafter, consequently, Itanagar PS case was registered under section Itanagar PS case number 178/2009, section 363/376 subclause F/34 IPC. So accordingly, my lord, the petitioner was arrested, and during after arresting and detection of the petitioner, after 48 hours, so he was on suspension, my lord. Suspension order is, my lord, lordship may come to page number 22, my lord. Annexure number 2, my lord. So after suspension, my lord, the department has appointed inquiry officers. Inquiry was conducted against the petitioner, and inquiry officer has submitted his report to the concerned authorities, and accordingly copy is furnished to the petitioner on 7 July 2017, my lord. So he is just finding, inquiry officer has just finding that based on the charge sheet and based on the statement from the IO of the case, my lord. During the time of inquiry being conducted by the inquiry officer, departmental inquiry officer, he has never been examined the victim of the case, my lord. Only has examined the complainant, and complainant has denied of rape of the accused by the rape of the victim by the accused, my lord. So subsequently, my lord, thereafter, a part of concerned authorities. So accordingly, my lord, this petitioner was filed a writ petition before this honorable court, my lord, challenging that suspension order, my lord. So during the pendency of suspension or the challenging of writ petition, my lord, in regards to suspension order, so subsequent, my lord, impugn order is passed by the authorities on dated 18/12/2024, my lord. So lordship, I'll take to page number 46, my lord. Is suspension order, my lord. Yes, I'll operative portion, Lordship, I'll read out operative portion.
46,
My lord, page number 46.
46 removal order.
Yes, my lord, removal order, my lord.
We have read this.
Yes, my lord. So, my lord, so in that case also, the root cause of the case, when he was arrested and in connection with Itanagar PS case 178/2009. So trial was completed and this petitioner was also acquittal from all charges, my lord, from the Learned Court of District and Session Court, UPI, my lord. So now the petitioner is challenging the impugned removal order dated, my lord, 19/11/2009.
Order passed in the earlier rate petition.
My lord.
Where is the order passed in the earlier rate petition?
Yes, my lord. Lordship,
in your writ petition, we don't find the trial court order. Is it annexed? I did not notice.
My lord, trial court order has not, a judgment copy I have annexed, my lord. Judgment and order copy I have annexed, my lord.
Where is that page?
My lord, that is in page number, starting from page number 48, my lord, which I submitted before the concerned authority.
48.
Sorry, my lord. Page number 86, my lord. Page number 86, I submitted additional representation to the authorities for consideration of my ground, and enclosed with a judgment copy, my lord. Page number 88, my lord. Starting from page number 88 to 97, my lord. The operative portion, lordship. Lordship may find page number 95, my lord. So, there in the trial, my lord.
Yes, what the state is doing? Ms. Wangmo? This is a very serious matter.
Since last 2015, last 15 years, I was
No,
kept.
it will go against you. Serious matter means not in your favor, against you, heavily against you. You know what has happened?
Yes,
There is a sexual assault on a minor girl. Because this I missed it out. It's not there in the index. I did not read it. Here is a case where a 12-year-old minor girl was assaulted, and the trial proceeded under 376. It's a miscarriage of justice. We would order this matter to be placed before the Honorable the Chief Justice, or direct a suo motu case to be appeal to be registered. Is the state slipping over it? How can you allow this to happen? 363, 367, 2F. Allegation of sexual assault on a minor girl. We are issuing notice on this, and we are also issuing notice why the suo motu appeal should not be registered. No, not even without jurisdiction would be what? Appeal or a revision? See? issue notice in your case, will also issue notice why an appropriate appeal or revision should not be preferred suo motu against this order.
My lord,
This
in fact,
shall
there
not
was
be-
no, it was a mere allegation, my lord. There was no such incident took place, so.
Okay. So, if there's a mere allegation of murder, you will try, make the trial under a simple injury case. Under which law? Under which law the POXO can be omitted?
My lord, this is 2009 case, my lord, when POXO was not implemented. Itanagar PS case, my lord. POXO law was from 2012, my lord.
Yes, you're right. You're right there.
My lord.
2009.
2009 case, my
Date
lord.
of
Itanagar
offense,
PS.
25/10/2009.
Yes.
You're right.
Yes. My lord, here in the case, my continues that there was.
Issue notice then.
My lord.
It was good thinking on the legs.
Yes.
Appreciated that. I heard Mr.
N. Rama.
N. Rama, and counsel for the petitioner, as well as Ms. T. Wangmul and the government advocate appearing for for all the respondents.
All the respondents.
All the respondents. Next para. The the removal order at page 46, number so and so, dated 18/12 to 2024. Is and and leaves consequential thereto. No, wrong. Removal order date so and so has been assailed by filing this petition under Article 226 of the Constitution of India, including prayer for consequential reliefs. Issue notice returnable in 4 weeks. Extra copies of the petition.
My lord, I have also challenged suspension order that at 19/11/2009.
Suspension order will merge. That challenge is maintainable.
And my lord, appeal was filed and it was also dismissed. So I have also challenged that appeal dismiss order that at 15 September 2025. It is in page number 98, my lord.
Page number 98.
Yes, my lord.
Okay. And the order of dismissal of appeal dated 15/9/2025. That also had other challenges also. But your prayer for the interference with the suspension order has to be rejected outrightly. That would merge with the final order.
Yes, my lord. So that prayer may be covered with all the suspension order, my lord. I have already made prayer for revocation.
Notice is not issued on that.
Yes.
issue notice, return in 4 weeks, extra copies within 2 days. The departmental records in respect of the petitioner be produced. Next para. The learned counsel for the petitioner has submitted that the suspension order dated 19/11/2009 was also been assailed. Full stop. As the order of suspension merges with the final order of punishment of dismissal from service. And the prayer for reinstatement is based on the judgment of acquittal passed by the learned trial court, comma, the said part of the prayer challenging the suspension order dated.
My lord, I have also challenged the departmental inquiry order being submitted by inquiry officer, which was based on inquiry conclusive that based on the IO statement by the IO as well as charge sheet, my lord. Whereas he has never been taken examination of the victim, my lord, victim in the case, my lord.
You have participated in the.
Yes, I was participated, my lord. So I was
After that, how
examined.
can you challenge that
Yes.
part? Any authority on the point that that can be challenged now?
So I have made, my lord, subsequent representation, series of representations.
When that part of the prayer challenging the order of suspension is outrightly rejected. Let's start off for weeks.
Yes. Much obliged.
Item number 5.
Please, Lordship. Lordship, through this writ petition, the petitioner are challenging the approval letters, orders, communication, direction, extra in regard to Racing Hydroelectric Project 12 megawatt located at Le Puring Circle under Papumbare district. So, which has been issued and passed in total violation of existing prevalent laws. So, Lordship, for more clarity in the facts of the case, I may be allowed to read the synopsis for the clarity of this court.
You don't read it, tell us what is it.
Okay, Lordship, this whole thing has arisen by signing of memorandum of agreement between MS Gekam power developer in between and state of Arunachal Pradesh, represented by Secretary Hydropower, in the year which has been entered between them in the year 2019. Thereafter, DFO, the Divisional Forest Officer, through his site inspection report 31/8/2020, it's page number 130-132, Lordship. This is the base. This is the report which has the base, and through this report only the state clearance and central approval has been obtained.
130,
130 and 132, page number.
130.
Yes, Your Lordship. Uh, 130 Annexure 11 says. So, Lordship, actually what we are submitting is that this is our land, our community land. But through this site inspection report of DFO, he has declared our land as forest land without any official records, there is no record of notification that our land belongs, our land comes under forest. It unilaterally, arbitrarily, and with on discretionary authority, he has issued this report. And we have subsequently, and this report has been hidden from us for many years. Only after filing RTI, we have obtained this document, and subsequently we have been, we have filed the objection representation against this one.
Where is your objection?
Page number 218, Lordship. 218.
Which was that page you showed us earlier, that 130?
Yes, yes, 130.
130.
And X11.
That survey report,
Page number 130, Lordship.
130.
Yes, yes. Site inspection report, Lordship.
Mr. Rathan, we are issuing notice then.
Can be issued, ma'am.
Lordship, actually, here the whole process is not over, but construction is going on, Lordship. That's why if
For construction, you have to deposit some money. Construction, we are not stopping. This is hydroelectric project. We are not stopping.
Lordship, one more. This subsequently, this site report has been reconfirmed. This one subsequent by.
You see, you are conferred with the right of appeal. You'll get more opportunities. We can't give you a stay without making a deposit. It's a what do you call it? It's a power project. You have to deposit at least 100 crore rupees.
No, not 100 crore rupees. It's a private project, the 12 megawatt project, a small project.
So tell us the cost of the project.
Cost of the project, I don't know. But Lordship, the site inspection report has been.
It was a lesser project. There would have been no objection.
Lordship may kindly look into 387 page number. 387 page number.
387.
Yes.
Public projects, we are not staying.
This is a private project, sir. Private projects, Lordship.
Private project, but hydroelectricity is, I will not produce to consume myself. You see, even a small, nowadays under the new power scheme, even if you install a solar power in your rooftop, you can connect it with the grid and send it for public consumption. So every power project is a public project now.
Lordship, page number 387.
Yes, we are there.
387. This is a letter by deputy the divisional forest officer addressing to Deputy Commissioner UPIA on dated 5/9/2025. Very recent letter, where the status of the land, the component one, the petitioner land, is again declared as community land. Earlier the DFO declared it as a forest land. Now subsequently he declares it as a community land.
Same officer.
No, yes, same, not same officer, same office.
Same office.
Yes.
Yes, your officer. Morning he gives another letter, evening he gives another letter.
No, my lord. I think my learned friend, they are confused. In page 183, what it says. 130, my lord.
30.
Yes, the site inspection report. I think they are very confused.
Yes.
130. It says this is site inspection of the land, and then so and so this is unclassified state forest, madam.
Unclassified state forest.
Yes, legal status of the forest land proposed for diversion. Unclassified state forest, my lord.
This will be unclassified state forest. Who is the administrative head?
My lord, it is the forest department itself, my lord. Here, my lord.
Please come to page 127. Pursuant to notice dated so and so, a committee is hereby constituted with the following members to carry out ground survey.
Yes.
Circle officer Leporian. Number 2, DFO Sagali. Correct?
Yes.
Now come to this page 387. Same officer, Sagadi.
Yes, my lord. My lord, it is not disputed till now. What is a unclassified state forest? My
Oh,
lord?
acha, you are saying this is reserve, it's not reserve.
It's not reserve forest,
Unreserved forest.
unreserved forest. It's an unclassified state forest. My friends, they are not understanding what is an unclassified state forest. They are assuming it to be a reserve forest.
Lordship, if that is the case, then there will be a clear violation of Article 14 and 21 of Constitution of India.
Just a moment.
And Section 4 of Assam Forest Regulation Act.
Just tell me, some, in this case, some awards were passed. Is any of the petitioner beneficiary of any of the award or payment made?
No, Lordship.
Earlier you had filed a writ petition. What happened to that?
Writ petition, 3 writ petition we have filed, 2 we have withdrawn, but 1 writ petition, page number, page number. Page number, Aram sir. Lordship, I would like to take the, Lordship will find in page 259.
259.
Yes.
Inclusion तो हो गया ना
Operative para, Lordship can see.
This what had happened after this order?
Here, NIL order was issued. But again, this NIL compliance to the deputy commissioner has issued a NIL, issued a letter, directing to circle officer, concerned circle officer, to conduct a NIL between these 2 villagers, petitioner villagers and another rushing village. But NIL was not attended by the rushing village. Respondent, private respondent villages. Neither this private respondent appeared before nor any of his representative appeared in the NIL. So the NIL couldn't completed. So there was also a total violation.
Okay. Yes, Mr. Ratan.
Today, I would just pray that notice may be issued for today, my lord. Otherwise, if I make my submission, I would first make that legal submission that what right of the petitioners have been violated.
You know, if they can claim that it's a community land, then you always have a right.
My lord, that's why when there was a land acquisition under section 10 of the Balipara frontier regulation, my lord, Zoom land regulation, when that notice for acquisition was published, their objection nowhere says that it is their land. Their objection was not against the acquisition of the land. Their objection was against the construction of the idol.
Where is that?
My lord will kindly come to 207. This is the public notice for land acquisition. 207.
Yes, 207 is the
public notice.
Then this is objection at 209.
209 is the objection. My lord will see the objection, my lord.
But here also they are saying that it's a private, the Papi Panchayat land.
My lord, the award was the owners of the land were identified.
Okay. Where is the award? That is why we refer to the award. Where is that?
338, my lord.
38.
338.
338. Okay.
Yes, sir. This is, but incomplete. They have. My lord will kindly see how it was carried out at page 339. ma'am.
Read it. Okay.
Joint measurements was done. Names of persons whose land under acquisition was reflected from so and so physical ground survey by the survey team during assessment, and the same are shown in award statement. No other person except shown in the award statement has claim ownership or claim compensation with regard to the land under acquisition and compensation thereof. Dispute plot, if any, had been reflected in the marked column in the award statement, my lord. Award statement has not been annexed, my lord. It's incomplete, my lord. But the landowners have been identified, my lord.
Which page was that? That objection and this notification.
Objection, notification is at 207.
Just a moment.
Public notice 207.
Just a moment.
Lordship, before going into these facts, some legal issues are there because before this stage 1 and stage 2 clearance has to be issued only after obtaining following the due process of applicable law under Scheduled Tribe Forest Right Act and guidelines issued by Ministry of Environment Forest. But here, this representation grievances are being heard only after final approval is granted. Supreme Court judgments is there. Stage 2, the final approval can be granted only after compliance of these relevant laws and guidelines.
Which relevant law?
Yes, yes. The Scheduled Tribes and Other Forest Developer Recognition of Forest Right Act 2006. Here, I would like to take Lordship.
First of all, you decide, you sit down and then decide whether it is a forest land or non-forest land.
Because that's why, because
it's a community land. If it's a community land, it can't be a forest land.
Yes, yes.
If you are claiming right on the forest land, then your writ petition dismissed right now.
No, we are claiming community land, not forest land.
But you just now said that Forest Dwellers Rights Act should be considered.
No, here this guidelines has been mentioned. This rule, how this.
I understand.
Because diversion can be taken in private forest land and this one forest.
Who are you? You are the land is a forest land, unclassified forest land or not forest land?
That is our land, which they have shown as forest land.
So then assessment has to be done by considering the Forest Act, that what you call Traditional Rights of Forest Dwellers Act. That is to be applied.
Yes, Gram Sabha should be applied. We are saying Gram Sabha and sub-divisional level committee, those mandatory procedures should be applied.
From which act?
Under Scheduled Tribe and Forest Dweller Act, 2006.
Give that book. Scheduled Tribe. In this Scheduled Tribe Act, it is independent of forest land also. You're trying to say that?
Yes, yes. Because it's a law protecting the tribal lands.
No, not this. Scheduled Tribe and protection of right of forest dwellers. That. What is the name of the act?
Scheduled Tribes and Other Traditional Forest Dwellers Act 2006.
Is S25.
Here, section 4.
Start from introduction first. Read the first line of introduction.
Yeah, chapter 3, recognition, restoration, and vesting of forest rights and
different page than I am. Please read introduction, first line of the introduction of this act.
This act may be called Scheduled Tribe and Other Traditional Dwellers Recognition.
Not on the same page. In this book, after the index, you will get a page which is called introduction.
Okay. Lordship, Mary. Forest and forest dwelling tribal people are inseparable. One cannot survive without the other. That's
Now, please stop here. Now come to the next page. An act to recognize. Read that preamble.
An act to recognize and vest the forest rights and occupation in forest land in forest dwelling scheduled tribes and other traditional forest dwellers who have been residing in such forest for generation.
Correct. Now you say that without forest also this can be applied. You're fundamentally incorrect.
Because we have been residing there. This is our community land.
Please tell us, it is forest or non-forest? Mr. Ratan has demonstrated that it's an unclassified forest. So is it your land, classified forest or unclassified forest? Tell us.
This is our community private forest land.
So not
Lordship, that provision is there.
You have come to forest land now.
No.
Now what happened when these protests were made? These objections were raised.
Yes.
You are one of the signatory.
Yes.
Correct.
Yes.
So after that, this is the second round of litigation. 2 writ petitions you have already filed. This is the 3rd writ petition.
Yes, Lordship.
We put your question, how while a writ petition be maintainable under order to rule 2. Can you file a piecemeal writ petition one after the other?
No, actually, Lordship, here that all materials has been kept secret.
Next time you beg that reply.
Okay.
We are putting your question on maintainability. We are not granting any stay. Mr.
N. Saha.
N. Saha, Learned Counsel for the petitioner, and Mr. N. Ratan, Learned Additional Advocate General for the state, representing respondent numbers.
3 to, my lord, 14.
Who will be number 1, the Union of India?
Yes.
Yes, I'm sorry, I didn't see you. Mr. M. Katul, Learned CGC for respondent number 1.
1 and 2.
1 and 2. Additional Advocate General for respondent number 3.
To 14.
3 to 14. And okay.
Oh,
and Mr. T. Chagam, Learned Counsel appearing for respondent number 15. Aviator. Next para.
Lordship, I will like to take the Lordship attention towards 432, last 432. This is a letter from Ministry, guidelines, letter from Ministry of Environment and Forest.
432.
432.
Yes.
Here, this one, small letter A. Here it's written that a letter from state government certifying that complete process of identification and settlement of rights under FRA has been carried out for entire forest area proposed for diversion with record of all consultation and meeting held. Here the word used as consultation and meeting held is used. Though forest word has come, but consultation and meeting has been used. And say para 6, a letter from each of the concerned Gram Sabha indicating that all the formalities, processes.
You were aware from your objection, it appears that you were aware that acquisition process is going on. You made an objection.
No, recently only.
Whatever be, relates to acquisition.
Yes, we have objected that one.
Now, yes, okay. You have objected to it. Now, was your claim allowed for compensation? Are you a beneficiary?
We are not a beneficiary.
Not a beneficiary. Then please tell us, how do you assert your personal right? If it's a community land.
That's why here provided that Gram Sabha, the mechanism is Gram Sabha and subdivisional level committee. The mechanism, statutory mechanism under this law.
Come to your objection. Have you raised that plea?
Yes.
Where is that? It's not there. Your objection is 8209. You see, come to paragraph 4. No, paragraph 4 of that page 210.
210.
Yes. This is your objection. Any doubt? This is not your objection. Page 209. Is it your objection or it is not your objection? Any doubt?
This is our objection.
Your
We
objection.
admit.
Come to paragraph 4 at 210.
Yes.
That racing village is far away from the proposed area.
Yes, that is the fact. We have the map which has been countersigned by circle officer.
How come such a private party's developer imposed forcefully without due consideration of land and river owners? So you claim to be the owner of the land.
Yes.
And your ownership of the land is divested because there is no award in your favor. Having lost there, this is another indication you have made.
No, not award, Lordship. Actually, this is the matter of alienating our land. They are forcefully taking our land. Because their jurisdiction, if project area lands is shown as this is proved declared as their land, we will lose our large portion of land territory area. Jurisdiction which for which circle officer has issued a map also. Showing that portion of area comes under our jurisdiction.
Anyway, that the question of maintainment will still be kept open. You filed an earlier writ petition. In 2023, your writ petition was filed when? After this objection?
Yes, yes.
Correct. That's why we said order to rule 2. You can't file multiple writ petitions claiming one relief after the other.
Because lots of developments came out subsequently now. And all this material were hidden from us. Through RTI only subsequently we came to know this villagers.
If you are prepared to answer the question on law, we are ready to hear it. Make your submissions on multiple writ petitions.
No, actually, Lordship, now whatever I have submitted, that is my, and this one, and we have withdrawn with the liberty to file a
Tell you
press.
that we are not hearing your submissions.
No.
We are ready to hear it.
Yes.
But you have to respond to the court query.
Yes.
Our query is that under order to rule 2, that piecemeal litigation cannot be sustained. Make your submission on law.
Because Lordship, we do accept that court observation in that regard. But this case being very sensitive and document has been all respondent authorities are playing in one side. And we the villagers in one side. Villagers usually don't know their rights. So we one after another records come when whole material we can't get in one go. That is the fact. Due to our ignorance.
When we hear it on the next date, if you are prepared to hear today, we are hearing it. If you are postponing, you want this question to be postponed, we postpone it. It is your choice.
Lordship, one more status report of Deputy Commissioner.
No, it doesn't take us anywhere. First of all, are you ready to make submissions on merit on the multiple writ petitions? If you're ready, then we hear it. We will look into every document. You want us to pose a query and then postpone it on the next date of listing? We are ready to do that.
Okay.
It's your choice.
Pose the query for next date. Lordship.
Okay. We don't want to disappoint you. You are so prepared with hearing. We don't want to disappoint that we are not hearing you.
Yes.
Correct?
Yes.
But when we hear it for a purpose.
Yes.
which is the 2210-2025 memo, which you are challenging.
Page number 104, Lordship.
Have you made a statement as to which people are ready to accept compensation and who are not ready to accept compensation?
No, actually, from petitioner villages, no one has been given in a list of beneficiary, Lordship. Actually, this compensation issue won't arise for petitioner side because their land has been shown as forest land.
Where is the award? The compensation, this compensation must be referring to some persons. Who are those persons who will be getting the
My
compensation?
lord, 338, my lord, which my lord has seen earlier. 338.
338.
The list of beneficiaries that has not been enclosed by them.
Just a moment. Award, yes. Yes, list of award is not there, or the beneficiaries are not there.
Yes, we are not in list of beneficiary.
It's not there. So that first prayer is dismissed at limine. We can't tinker with the award without the beneficiaries being
Included.
given a right to address us.
Because here beneficiary list is not there, Your Lordship.
No, they're not even respondents. That's why we are coming one by one.
Actually, we don't know who are the beneficiary, Lordship. Even I think state still don't know.
State doesn't know, and award is passed.
No, award order has been given, and award has not been given yet. This is the award which has been installed right now, but I think recently these days to 2 or 3 days between they will issue another award, I think.
Page 338, which Mr. The Advocate, Additional Advocate General has shown, has this been withdrawn? This award is withdrawn.
No.
How can another award be passed?
Yeah. 16. Director, sir. Director.
No, it's okay. We are this 3-1. We are dismissing it. Now, where is that 1610? Your prayer number 32, 1610. Where is that?
Page number 105, Lordship.
105. Okay, this also goes with prayer number 1. Then prayer number 3 is 18-8. Eighteen 825, 3-3.
Is it 117? 117.
Page number 117, Lordship.
117. Do you have a copy of this writ petition, WBC 45 AP 24?
Copy. Copy we don't have. Order.
Yeah.
Order we have it. No,
Where is
copy
that?
don't have.
Where is the order? Are you a party in that writ petition? WBC 45?
No, no.
306, page
306.
They are the petitioners, ma'am.
Hmm?
They are the same petitioners.
They are the petitioners.
306.
Okay. Where is this 23/2/2024 where your representation was disposed of? 23/2/2024, your representation was disposed of. Where is that? You see, this is a classic case. We always hear or read in the what you call articles. What you call, this is the classic case which we hear from all seniors, from which we have learned that in courtroom you must know when to stop. You see, we were not giving you an interim relief. For that, you make your submission, and now we are looking into the documents, and it is resulting in dismissal of many of your prayers. It will basically make this writ petition redundant. So, knowing when to stop is again very important art. 23/2/24. Your representative are disposed of.
Yes, Lordship. We are not denying that fact.
You're not denying. Then it-
Because we are not denying due to the reason that since from initial public notice.
have some patience.
Yes, sir.
If your representation was disposed of pursuant to direction passed by this court in WPC 45, and you are not aggrieved by that decision, it seals your fate. Your representation again stands dismissed. In your representation, you claim your right, and that was disposed of by the deputy commissioner. That is not under challenge. Your independent challenge.
No, that is under challenge. The order of deputy commissioner is under challenge.
Where is that? That's why we are asking you, where is 23 to 24? This date 23 to 24, we are getting it from that order. 107 you showed us, I think.
Lordship will find in 314, Lordship, page number 314.
314. No. That last letter, Mr. Radhan, what was that letter you showed us last? I forgot to tag it.
The award, my lord.
Use that award.
Award is at 338.
338. No, not the 338. 20. It's 26, 525. 18, 825 and 26 to 25. These two, out of these two letters, we'll find the date.
Thank you. 33. 33. Twenty-six, 8. 117.
Pursuant to the order of this court, there was a direction to dispose of that representation. And the representation was disposed of. 40, that after this 45 of 2024, there's a direction to dispose of representation 29, 12, 23.
310, my lord.
310.
Yes, ma'am.
Or 324. No, this is spot verification. This is not pursuant to the direction of this court, not in 45. This is an independent exercise. 23 to 24, disposal of the representation.
23 to 24.
You see, will tell you that sequence, that page I lost somewhere. I did not mark it and I forgot. Now in page 309, there's a direction to dispose of the representation in 2912. This 2912 representation is referred at page 310.
Yes.
Okay. Now this takes away, on reading page 311, it takes away your other ground. 311.3. The other ground panchayat, Leporajing panchayat, they gave no objection.
That is regarding there is two
villages.
No, two section. One is component one. Component one is the petitioner village, and component two is other party village. So they have taken from that Gram Sabha consent they have taken. From component one, they have not taken.
Twenty-six 25 letter of deputy commissioner is at which page? Your prayer number 3-4.
This is the award, my lord. 26/5/2025.
That is the award.
Yes, 338.
And then 5,
Award by the deputy commissioner.
4-3 by the deputy commissioner. Which is page?
338.
No, there are two. In serial number 4 is also one dated 26/5/25. Impune award.
Award.
26/5/25.
Yes, that is the impune award.
And 4-3/24 is another award, another order. 4-3/24.
4-3, that is at
page
page
310.
310. This is whereby the deputy commissioner has rejected their prayer and to go ahead with the joint verification report, my lord, already conducted.
Okay. Inspection come verification report of 4/12/23. That is a page.
412 received by disciplines and joining. Or 12/23. 412.
You just will not waste our time. You just in the side of this, all these prayers, you have made these letters. Tell us which page they are. We'll pass out those after some time. Otherwise, all of the
412 is at
council will be
page
waiting.
280.
No, just do the homework and tell me. No, otherwise, all the other councillors waiting.
Yes, ma'am. Yes,
Just
ma'am.
give me those page numbers.
Yes.
412 is at 289.
No, whatever be, just give me a list. Otherwise, I'm finding it difficult. It's taking up too much of time. Tell us the page numbers of these prayers, whatever annexures are there, whichever documents are there, please give us the page number. After that, we'll pass orders.
All right.
Taking up next case in the meantime. 6.
Item number 6.
Right, please go ahead.
Yes.
This representation is directed against the retention order of the respondent number 4. But at annexure.
How are you
13,
affected?
Page 48.
My lord, I'm sorry, my lord, caveat is there, my lord, filed by Mr. Tafo, caveat is there, my lord, that has to be discharged first, my lord.
Okay. Give it will discharge. This automatically they will do.
Not been furnished with a copy of.
No, not given. Oh, then we have to adjourn it. Mr. T. Patil, Learned Counsel for the petitioner, and Mr. R.H. Nawam, then it's Additional Advocate General for the state are present. Next para. Mr. P. Tafel, Learned Counsel appears for respondent numbers.
It will be 4.
Number 4.
For number 4, my lord.
Not, I have served a copy.
It's okay. He'll have to take instructions. Respondent number 4 of the caveator who submits that the copy of the representation has been filed just now. Accordingly, the matter stands adjourned today. List again on Monday.
Tomorrow.
Tomorrow, yes.
Tomorrow, my lord, it's a transfer posting.
Okay.
Obliged.
List on 14/11. You want to do it on Children's Day?
Item number 7.
Yes.
Wait, please, Your Lordship, But here, the president is questioning the
Appointment of chairman.
Yeah, chairman. Because Bharat, earlier he was the chairman of APSC, that means the National Police Commission. Now he is again appointed as chairman of the Regulatory Commission. Now, the Article 319 of the Constitution, Mala, 319, that prohibits the second employment. And that is a whole issue, Mala, that is a whole issue.
Yes.
Your Lordship, may I examine the matter at para 6, I have given his appointment. That paragraph 6, Your Lordship, page 7. That had the order dated 11/3/24. She is setting Naksad, he is responsible for on the recommendation of search committee dated 7/3/24. The Honorable Governor of Assam appointed Sri Sering as the chairman of Arunachal Private Education Development 2000 for 3 years or until further order at the LCL. Indicating that he could not have been appointed in view of provision of Article 319 of the Constitution. As such, the appointment be declared void and so on and so on.
Yes,
Now,
Mr. Jamo.
That is a legal question, Mala.
Is he setting the appointment?
His appointment
He's
order
setting the
is
appointment?
page 33, page 33, Your Lord. Page 33.
My lord, appointment is
33.
appointment was given
On
by
the
the government, my lord.
Annexa 1. On the
Advocate General was there, my lord.
7/3/24, the government of Assam, Arunachal Pradesh is pleased to appoint Sri Sering so and so district person.
You will appear for the
Commission, my lord.
For the commission, who is appearing?
Regulatory Commission.
Regulatory Commission, and Mr. Ratan was here, my lord. He's he's the actually appointing authority.
Yeah, and
should just
by virtue of
call him if he's available.
By virtue of this Annexa 2 at page 42,
Just a moment, let Advocate General come.
Mala.
After some time. Advocate General. Item 8.
Item number 8.
Yes.
Your
You're
Lordship,
challenging the order.
the termination order.
Okay.
That is at page number 107, Your Lordship.
107.
107. By this order of termination, your lordship will.
Okay, we issue notice.
42.
We issue notice. What's your name?
T.Y. Bhutia.
CY?
T.Y. Bhutia.
TY. Okay, I
Yes,
forgot.
lordship.
Ms. T.Y. Bhutia, I heard Ms. T.Y. Bhutia and counsel for the petitioner. And you are appealing for?
Yeah, for state respondent, my lord.
All the respondents?
Yes, ma'am.
And Mr. T. Kagum, the next standing counsel for the education department, representing all the respondents. Next paragraph. We are filing this writ petition under Article 226 of the Constitution of India. The petitioner has said the termination order dated 16/11/2023, signed on 23/11/2023, issued by the Commissioner within bracket Education, Government of Arunachal Pradesh. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the standing counsel for the Education Department within 2 days. List after 4 weeks.
Deeply.
Item number 9.
Yes.
Alert, I'm challenging the impugn NIT dated 24/10/2025, my lord. My lord,
This is something which we can't do. It will be the authorities who will clarify. The scope of work is already defined.
no, but then my lord, may kindly see annexure, page 38, my lord.
38 years.
38, my lord, already an NIT has been issued, my lord,
You see,
plotted, my lord.
they know what work for it is issued.
Yes, my lord, the work is for transport. Now, they have added handling now, my lord. From FSD Bandadua, Harmoti to FSD 0, my lord.
That's why we are saying they know the scope of the work. If they are awarding two tenders for same work,
Yes,
they
my
know how to handle it.
Yes, my lord. But then, if again, my lord, come to page 57, my lord. I have been already awarded a contract, my lord, where I'm already handling that contract, my lord. Now,
where is that earlier contract?
57, my lord.
57.
No, my lord. Handling, my lord.
Yes.
50, my lord. 50.
Yes, ma'am. Mr. Singh, will you be affected with this?
Yes, my lord.
My lord, my submission will be as of today, no rights has been violated. I will complete my submission. Let him complete, my lord.
He's already made this statement that
Yes,
it's
my
the same contract, part of the contract. You are
Yes, my lord. As far as the first contract is concerned, that is 11/7/2025 that the FCI have issued. That is for the RTC transport contract, my lord, from the for the area RH Harmony to FSD 0, my lord.
Where is the petitioner's earlier order? Where it is that?
50, my lord.
50.
50, my lord.
Shows the handling part of the work here.
Yes, my lord. And
show that.
My lord will kindly see the work order, my lord, at page 56, my lord. 56, my lord.
Show the handling part.
Yes, my lord. 50, handling part, my lord, in page 50, my lord. Second column, my lord. Handling contract at FSD 0 on regular basis for the period of 2 years, my lord.
So this is the new tender.
No, this is the old tender, my lord.
Old tender.
Yeah,
Okay.
I'm already handling it, my lord.
It's okay. Now, yes.
My lord, may kindly tend to.
Yes.
So that at page annexure 6,
Page.
50.
He is a handling contract at FSD 0, my lord.
Yes.
Food storage depot 0. Now the standard which was quoted by the FCI, that is 11/7/2025, my lord, may come to page 38.
38.
No.
Yes.
Page 38, my lord. This is the road transport contract EXRH Harbuti FSD Bandadeva to FSD 0 way bridge for the entire distance, my lord. Petitioner has participated in this tender along with other 4 tenderers, my lord. In that tender, my lord, petitioner has given an undertaking that he will abide by the terms and conditions of the said contract, my lord. The entire contract has not been Next, my lord, may I make great leave of this on code to produce that service condition, my lord, terms and conditions, my lord. Actually, I have received the copy today morning, so I am giving only the relevant page, my lord. This is an application. The terms and conditions may kindly be that 4, my lord. That bunch of papers, my lord. 4, my lord. It is at page 2 of 7. This is a signed contract, my lord, signed MTF 4.1. The buyer does not, may I read it, my lord. The buyer does not guarantee any definite volume of work or any particular pattern of service at any time or throughout the period of the contract. Now, 4.2. 4.2 is relevant in this case, my lord. The buyer have the exclusive right to appoint one or more service providers for any or all the services and to divide the work between such service providers in any manner that the buyer may decide, and no claim shall be lie against the buyer by reason of such division of work. So he has participated in this tender. Now, in that tender, only technical evaluation has yet to be completed, my lord, because of for want of the tax clearance. We have taken a opinion from the chartered accountant with regard to the taxation of certain bidders, my lord. That's why that technical evaluation has not been completed with regard to the 11/7/2025, my lord. That's why I'm saying that the no right has been violated as on today. Now coming to the next tender, that is at page 24/11/2025, page 32, my lord.
Just on that. You participated in the tender?
No, my lord, that is not my case, my lord. If, my lord, give me 5 minutes, my lord, I'll explain the whole case in 5 minutes, my lord.
One single page documents is a part.
Let him complete, then we'll come to you.
Yes, my lord. One single page document has been given, the letter of the petitioner dated 8/7/2025. There's a part and parcel of the tender document, my lord.
It is, that is the previous tender, not
Yes,
this tender.
18/7/2025, 11/7/2025. First tender, my lord. Clause 2, my lord. I hereby certify that we have read the entire terms and conditions of the tender documents, including all documents like
No,
annexures,
that's okay, but tell us
which
only
form
one
part
thing.
of the
Mr.
contract.
Singh, just tell us one thing. Zero Depot, he is the handler.
He is handling. He
Correct.
that handling contract, which
Now,
will expire in
how will-
2027.
how will
Only at
the-
zero FSD.
How will the truck of the another contractor come and in the FSDs, in the concerned FSD of
Yes.
zero, who will handle that?
My lord, it is handling contract of the RH Harmuti, my lord. Railhead Harmuti.
No, no.
And FSD Bandardeva to FSD 0, my lord. Road transfer contract, first contract, my lord, 11/7/2025. This is a road transfer contract only.
No, in a simple man's language, he will bring the truck to the
No,
FSD.
he will not bring the, he will only handle right now he's only handling the loading, unloading at FSD 0.
No, my lord,
At zero.
absolutely
It's
wrong.
okay, just let me understand.
Let-
Please don't
let me
interrupt.
complete it.
I'm trying to understand something. I don't operate trucks. I
My
don't-
lord, my lord.
Hello, the petitioner is existing contract of handling contract at FSD
At
0.
zero.
That will
Now,
expire in
if
26.
somebody brings from Harmuti a truck
Yes,
to
ma'am.
zero,
Yes, my lord.
now who will unload it?
At present, he is unloading, my lord, at 0, my lord. Now, the 11/7/2025, this contract is for the RTC road transfer contract from RH Harmuti, FSD Bandardeva to FSD 0. This is a road exclusively for road transfer contract, my lord. 11/7/25, my lord. Page 38. Wherein he has participated. There are other four tenderer. It has not been, tender evaluation has not been completed yet, my lord.
Okay, so this does not cover handling.
This does not cover handling. This does not cover handling, and this tender evaluation, technical evaluation is pending, my lord, in this case. Now the now the second tender, that is 24/10/2025, page 32.
I'm again confused.
Well, there are two tenders.
There are two tenders.
Right now
This is the first
existing.
one. 11/7 is the first one.
First one is 11/7/25, that is page 38. 38.
Yes. The second one?
Second one is at page 32. It is dated 24/10/2025.
This has been impugned, my lord. This tender has been impugned.
He want to stay in this,
Yes.
NIT has to be stayed.
Yes. Now, this is, you see, appointment of handling and transport contract.
I'm coming, my
From Harmuti.
I mean, coming, my. This is now page 32, my lord.
Yes.
24/10/2025. Handling and transport contract for RH Harmuti to FSD 0, including handling contract at FSD 0. Now, my lord, the FCI is coming up with the pan India that the composite contract has to be given. The same contractor has to handle the bags also, loading, unloading, and used to transport the food grains through truck. Why it has been done, my lord? Because there is always a delay, because if a different contractor is for the handling and different contractor for the transport, my lord. So it incurs damages charges, delay in transportation. For coordinating, we are issuing the composite tender, my lord. This is happening pan India, my lord, in Meghalaya also, in Tripura also, in Assam also, now in Arunachal Pradesh also, my lord. So the technical bid has the last date of filing the bid, my lord, is tomorrow, my lord. He may also participate, my lord. So what I am submitting, my lord, his right has not been violated, my lord, because in the first tender 11/7/2025, yet tender evaluation has yet to be completed, my lord, where he
Once
has
it is
participated.
completed, the other party will create a right to do the handling at zero.
It takes 3 to 4 months to complete a
It may
tender
take 10
process.
years also. Time is not the essence right now.
My lord, as per the tender document, which I have shown, my lord, the buyer does not guarantee any definite volume of work, my lord. And the
You
next
see,
4.2, the buyer have the exclusive right to appoint one or more service provider.
That does not mean that you'll have two contractors for the same work.
No, he's only.
I can
he's
understand. That
He's
I
only
can,
doing.
You see, I can understand. You are made what you call standing counsel for, say, Department A. Department A does not guarantee you that every day you'll have court appearance. That we can understand. But if there is only one case and there are 3 standing counsel appointed for Department A, and in the entire year there is only one case.
My lord, we have the tender conditions which he is abiding by it. My lord, he is bound to follow that, my lord. That which I have shown, my lord. The buyer does not guarantee any definite volume of work. We can divide it also, my lord, or any particular pattern of service at any time or throughout the period of the contract. The mere mention of any item of work in the contract does not by itself confer a right and or confirm any right to the service provider, my lord. If he will be my lord, agree, my lord, always there, he can claim damages, my lord, as stated in the NG projects, my lord, para 23, my lord. So this should not be stayed, my lord. We will file our objection within very short time, my lord, affidavit in opposition. First, it may be fixed in first week of December, my lord. We will bring all the records, my lord. Let the tender process go on, my lord.
Yes, you're saying something.
My lord,
He is harping on that first tender, my lord, 11/7/2020, that he has participated and he has.
no, my lord. No, I'm not harping upon that, my lord. He is making a wrong statement, my lord. Now, my lord, my learned friend, he has said that now they have decided that one contractor will control all, I mean, the contract, the composite contracts, my lord. My lord, this contract is of 24/10/2025, my lord. My lord, here is a NIT for Balpung, my lord. It was invited on 7/11/2025, my lord.
Maybe one officer does not know what the head office is doing.
No, it is from the same head office, my lord. Now, they have only called for tender for transportation, my lord, not for handling, my lord. Now, he submits that it will be composite, my lord. No, my lord. 11/7/2025, my lord. It is only for transport, my lord. And my lord, if this tender goes along, my lord, now handling is already with me, my lord. If my lord come to page 56, my lord, my period is till 23/12/2026, my lord. Now there will be confusion, my lord. There will be conflict, my lord. As my lord has really pointed out, my lord. Now, page 57, my lord. This was a tender, my lord, invited on 29/5/2023, my lord. Now here, this is for only transport, my lord. From Harmony FSD Bandora to 0. Same work, my lord. Same route, my lord. The earlier tender was for handling, my lord. This is for transport, my lord. This is also been handled by me, my lord. And it is also for a period of 2 years, my lord.
This is expire on 4th of December, man.
But then still it is under me, my lord. I'm handling
that.
that.
4th of December, so we need to appoint a new contractor, my lord.
My lord will find a.
So till 4th December, don't disturb him. Mr. O. Patel and Mr. O. Patel and counsel for the petitioner, as well as Mr. B.K. Singh and counsel for all the respondents.
And form 2
Respondent numbers
225.
225. CGC, who is there?
CGC, Mr. Kato is there. He is not a necessary party, my lord.
Okay. None at present call for respondent number 1. Next, probably. The tender for handling and transport contract from XEX dash RH Harmuti HARMUTY to FSD0 via Weybridge issued on 24/10/2025 is assailed by filing this writ petition under Article 226 of the Constitution of India on the ground that a part of the said tender work relating to handling of regarding handling works at FSD0 is covered by the tender dated 11/7/2025, which was
Not 11/7/25, my lord. 11/9/24.
no, you said annexure 2. You only said annexure 2 is 11.7, NIT.
No, he is a handling contractor as per the tender dated 11/9/24, man.
Where is that?
Annexure 6, page
Page?
50. Page 50.
Page 50, man.
50. Tender 11/9/2024. Next, the issue notice returnable in 4 weeks. Extra copies of the requisition is served on Janet's standing counsel for the respondent 2 to 4 in course of the day. Say where you said issue notice, you also say issue notice, including notice on the prayer for interim relief, which is made returnable on 3/12.
My lord.
3/12/2024. Next, I heard both sides on the prayer for interim relief. The learned counsel for respondents for 2 to 5 has opposed the prayer for interim relief on the ground that the earlier tender granted to the petitioner would expire on 4/12/2020. 4/12/2025.
4/12/2025.
There is only for my lord transport, my lord. But handling goes till 2026, December 2026.
So far as transport contract is concerned, and it is also submitted that in the earlier tender, the awarded to the petitioner, he had accepted the condition that there could be a split of the work or division of work with others, for which reliance is placed on clause number 4.1 and 4.2 of the terms and conditions of the contract agreement. Full stop. Next, on a query of the court, the learned counsel for respondents 2 to 5 has submitted that the finalization of tender would take some time.
Take some time.
Full stop. Explain that view of the matter.
2 to 3 minutes.
In the event the question tender is finalized, the work allotted to the petitioner shall not be allowed to hamper till the next date of listing. Next para list on 3/12/2025.
We will not disturb.
Or the petitioner will not be hampered till next date of listing. In the event it is finalized, if it is not finalized, you cannot otherwise also not do.
Tomorrow is the last day, my lord, tomorrow is the last day for tomorrow is the last day for submission.
You may also participate.
We are not saying that he is not making that prayer.
There is nobody in him.
But then, my lord,
participating in that.
if
That's
something,
not the prayer, we are not granting that.
Yes, ma'am.
Simple as that.
but because since I'm already handling and I'm already taking the transport, so it may.
The transport is till 4/12, my lord.
But ultimately,
It is for the contractor. They know more than us.
Yes, ma'am.
They are wiser than us.
Yes, my lord.
They're street smart. More better than, more smarter than us. So don't worry. Yes. In these two matters which were adjourned.
Item number 5.
You have given the page numbers?
Lordship, yes.
You take this and copy it in our, what you call, give him a piece of paper and then he will just note it. Because since I'll be going to the bar, I will be relying on you. That dates he's giving for NHS. Yes. Ask him to write it. I'll pass orders in the chambers. Since I have to rise in over this time.
One matter, my lord.
Yes, Mr. Das.
Item number 24, your lordship recollect. On last day, I came to the court. This is only, my lord, the application. That's only a small, my lord. This is regarding changing a cost title to be implemented. So far as notice to the private respondent is concerned.
Contempt matter.
Yes, yes. Your lordship just remember because ED and chairman, CMD, we have already cost title has been, yes.
24.
We can do our case. Item 7 now.
Maybe so that's all.
Yes, sir.
Fixing the details.
Yes, ma'am.
Yes.
We have to issue notice.
Yes, yes.
Okay.
And only one prayer, my lord.
Only the newly implemented ones.
Yes.
Who are those?
My lord, 6 and 7. Mr. Bhupender Gupta is a chief managing director, and Mr. Narendra Kumar is the executive director. 6 and 7.
Mr. Tiwari, you are present?
Yes, my lord, I am here.
Yes, we issue notice then.
Yes, notice is all right, but my lord, my case is prima facie, there is no contempt.
No, we'll see.
Prima facie, there is no
There is a
contempt.
contempt. You please argue at the time. First, notice, my lord. In addition, we'll take a dusty service also, my lord. In
But
addition
even
to
for
that.
issuing notice, my lord, if I understand the contempt jurisdiction perfectly well, even for notice, the honorable court has to be prima facie satisfied that the case for contempt is made out. Let us look into the nature of the order passed.
Well, last time, my lord, your lordship has order was passed in this case. Yes. Issue notice. Yes. There you go.
We'll permit the others to make submission on that.
Very well, my lord. It's all
Yes.
right. Just by the way, I pointed this out.
Yes.
It's okay.
We'll see.
Contact
You are
that.
right otherwise.
It's all right.
You are right otherwise.
Yeah.
Prima facie satisfaction has to be
Very
recorded.
well.
You are
Yes,
right.
ma'am.
Mr. D. Das, Learned Senior Counsel, assisted by Mr. I. Das, Learned Counsel for the petitioner. Next paragraph. Pursuant to the orders passed in the connected IA civil.
Yes.
270.
IA number 270.
270 AB of
Yes.
25, respondent numbers 6 and 7 have been included. Mr. Tiwari, you are appearing for whom?
My lord,
For gentlemen.
this is stage since my lord notice, right now I am only for the general manager, Mr. Gaurav Kumar.
For?
General
number one.
manager, Mr.
Number
Gaurav
one.
Kumar, respondent 1. Yes, my lord. Gaurav Kumar.
Gaurav Kumar, acha. Mr. P.K. Tiwari, Senior Counsel, assisted by Mr.
R.L. Tungan, R.L. Tungan.
R.L. Tungan, Learned Counsel, is present for respondent number 1. Issue notice on respondent number 6 and 7. Returnable on.
My lord, but just a humble prayer, my lord. We'll take a quick dusty service also, my lord. These men are suffering like anything. Let it be fixed on the next week, my lord. By Wednesday, we'll take a dusty service, my lord.
You'll go to Haryana and serve it.
Yes, no. Here, rowing and my lord in Delhi.
Mr. Gupta, your address is given at Haryana.
No, Faridabad. No, we will do it, my lord. Let us leave it to us. We'll do it. By any means, we'll do it. Let it come. From 2018, we have been suffering.
But can you serve it?
No, if we If you don't, sir, we'll fail it, my lord.
Question of 2018 doesn't arise because the earlier.
My lord,
award
let
was
me
set
tell,
aside.
Mr. Tiwari all the time is saying, please.
No, you
He is
are
not
also,
appearing
please
for
do
other
not do
party.
that. You
You
are
are
also
not
doing
appearing
it.
for the other
Don't
party.
do that. Do not talk
No,
about
no.
2018 because
No, no, yes, I will
2018
tell.
award was set aside.
Mr.
And we have
Tiwari,
not taken
don't
position
really
of that.
He's not allowing also, my lord. What is this?
Agitate
You
like
are
that.
also doing the
Yes.
same thing. You are also doing the
Yes.
same thing.
Mr. Tiwari, don't be agitated.
Why is that?
Both,
The
my lord,
expression
Mr.
of
Das is
agitation is-
agitated.
Yeah.
So I also got agitated.
Yes.
He's making a submission that it's pending
Yeah.
since 2018.
What is
wrong
this?
with
Which
that?
is not
Yes.
correct because 2018 award was set aside. Which
So
is
maybe
not correct.
set aside 2018 there was an award which was put
Mr.
to
Tiwari, according to you, if a suit is filed in 1960 and for some reason twice or thrice the decree is set aside by Supreme Court and comes again, you will see that you are aggrieved by 2025, not in 1960.
Here is a case, my lord, we have not even taken position of the land. They may be
Mr.
over
Tiwari,
eager.
no, it's not appreciated. Mr. Tiwari, you are a senior counsel. We can't appreciate that submission from you.
No, but that award was illegal, my lord. Award was illegal. That was the whole difficulty. That is why the award was quashed.
At this
And
stage,
your land
Mr.
is with
P.K.
them.
Tiwari, when
Land
a
is
senior
with them,
counsel
my
is
lord.
unnecessarily interjecting, though he's not
No,
appearing for
I'm
respondent number
sorry.
6 and 7, and therefore the court expresses its anguish in the conduct of Mr. P.K. Tiwari, learned senior counsel, for making submissions when it is not warranted, having not been appearing for respondent number 6 and 7.
My lord, for
Next
6 and
para.
7, I'm not. I'm sorry.
No, once the order is there. Now it is on record. We don't appreciate. We made you a
Well, I'm
polite
sorry.
request.
I'm sorry, my lord. I'm sorry. I'm sorry for.
No, not sorry. We requested you twice, but you insisted, and therefore there is an order. I will not recall that order.
It was on very well, my lord, but it was on different context altogether.
Whatever
was in
it
a
is,
different
we
context.
requested you not to perpetrate. That request you did not accept.
Then in that case, lordship may hear me on merit if the case for contempt is made out. Because, my lord, prima facie, lordship will have to be satisfied that there is a case for contempt.
As Mr. P.K. Tiwari further interjects in the matter, we presume that he is instructed to appear for respondent number 6 and 7. Because even
My lord, I'm
after
appearing for
recording the
one
previous...
only. I'm not appearing for 6 and 7. I'm appearing
Then
for
why
one
you are
only.
asking to hear on merit? What right do you have?
My lord, because it is, my lord, the case for contempt is not made out, even in respect of the one.
For 6 and 7, now you are arguing for 6 and 7.
6 and 7, lordship is
So
issuing
at this
notice
stage,
only.
Mr. P.K. Tiwari submits that he is not appearing for respondent number 6 and 7. Full stop. However, he insists that before issuance of notice on respondent number 6 and 7, the court should hear as to whether a prima facie case is made out against respondent number 6 and 7. Full stop. Accordingly, the court is inclined to record that in view of the nature of objection made, the service on respondent number 6 and 7 is completed on appearance of Mr. P.K. Tiwari, who has volunteered to appear and argue on merit. Full stop. Accordingly, list the matter tomorrow.
My lord, I have not
13, 12,
volunteered. My lord, I am not authorized to appear for them at this stage. I'm not
So
authorized
we'll
to
make
appear.
you appear now.
No,
Now
it is not a principle of law. Principle of law in respect of one.
We'll not show you, Mr. Tiwari, how you will appear. This passed a judicial order. Otherwise, you would not have interjected. Thrice you have interjected. You want us to hear on merit, we'll hear it. But we have made you appear now, which Mr. Tiwari was volunteering to give it by dasti.
But I have not.
And
I
now
have
you
not
don't.
said that. I have not said
Then
that.
why you are making submissions on the issuance of notice on respondent number 6 and 7? What right do you have got? Mr. Tiwari, it's not that we don't know how to administer ourselves in the court. Now, made you appear, now you file an application if you want to withdraw it. It's not appreciated. I come to court with a smiling face. I want to go out with a smiling face without taking any dead bodies. But you make an interjection at every point in this order. You want to dictate how the court should proceed when you are issuing a notice of contempt.
That was never my intention. I never, my lord, sought to dictate
No.
the honorable court. I will not do that. I cannot do that.
It's all we're taking up tomorrow.
Very well, my lord, I'll appear. But I can't appear for 6 and 7 because I do not have the authority at this stage. If they engage me,
Then
yes.
why did you make a submission? Why did you make a submission if you're not authorized?
It was on behalf of one only.
For one, you will object to 6 and 7.
I cannot. 6 and 7, I cannot object.
Then you withdraw your statement, your objections against issuance of notice.
I'm withdrawing my statement in connection with 6 and 7, my lord. I cannot.
Okay, at this stage, the learned senior counsel for respondent number 1 withdraws the statements made at the bar, objecting to the issuance of notice on respondent number 6 and 7. Full stop. Accordingly, he is discharged from appearing for respondent number 6 and 7 on the orders of the court. Next para, the petitioner shall take steps within 2 days for service of notice on the respondent number in newly implemented respondent number 6 and 7 by Dusty service.
Yes.
In addition to notice to be served by registered post with AD.
Yes.
List on 3/12/2025.
Item number 7, you also heard the part.
One second.
Let a notice
Can-
go, they have
One
accepted.
second. Can it be on next Wednesday, my lord? If it is, I don't know about Mr. Tiwari, next Wednesday,
No, let it be after a week.
after a week.
Because due this time from
Right,
Haryana, we
right,
can't
right.
really
I
say.
cannot do one, yeah?
Second, third, like set of us.
Oh, third. Yes.
Because you'll have to file an affidavit also, Mr. Das.
Yes, yes, yes. All right.
Item 7, I'll be appearing for 1 and 2.
Why to 90? Fourth, no, no. Second, or second, it can be Tuesday, my lord. Second. Second is Tuesday.
Okay, second.
Thank you. The three of us.
531.
531.
531.
531. Item 7. 531.
Number 17 will not see. Will be fixed tomorrow on for interim relief only. So it was fixed earlier for interim relief, it is not.
Also, it is here. Just wait. What is the nature of interim relief you're wanting? What is the matter?
Telling the suspension order, and they have extended it without following the process of law.
Okay.
Item 7, I'll be for 1 and 2.
Okay, item 7.
You come.
Heard Mr. Dikedas, known as senior counsel, assisted by Ms.
P. Borang.
P. Bora, learned counsel for the petitioner. Next, para. The appointment of the respondent number
4
to the office of
Malata. That's number 4. Selling Naksha as chairman for Arunachal
Chairman of the
Pradesh Private Institute
Arunachal Pradesh Private Institution
Regulatory Commission.
Regulatory Commission is assailed by filing this writ petition under Article 226 of the Constitution of India
that he was the chairperson
on the ground that his appointment is
prohibited by
operation of Article 319 of the Constitution of India. Issue notice returnable.
Malad. Annex 2 is the appointment as his earlier appointment, Malad.
It's okay. We have
The present appointment is Annex 1, page 33. Present appointment.
Wide order dated 11/3/2024. You're challenging 24 appointment now.
That is, present appointment is on 11 March 24.
Huh.
That
After,
as,
after.
after that, my lord, that he was earlier appointed as State Public Service Commission.
No, it's
No.
okay. You are challenging after 1.5 years.
My lord,
After 1.5 years, you are challenging it.
after no,
24 order now is 25.
25, my lord, yeah,
1.5 years.
1.5 years.
Issue notice returnable on. Give a date after 4 weeks. Requisite extra copies of the writ petition be served on the London. Government advocate for respondent numbers 1, 2, and 3. So the petitioner shall take steps within 2 days for service of notice on respondent number 4 by registered post with ED. The instructing counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next list on so and so.
Fix a date, my lord.
15/12.
Either 24 or 26 of this month.
26.
For hearing on interim order, my lord, because we say that only
For that, you will have to serve notice.
Yeah.
Without service of notice, we can't take it up.
True, my lord. Let this matter, hearing interim matter will come on the next date, my lord. That is on
Say notice.
24 or
notice will be there
26.
for interim relief. Okay.
Okay.
In your case, we'll pass orders after some time. There's.
My lord, can I make a prayer, my lord? My lord, item number 10, my lord. It was a motion item, my lord. That's because, my lord, a date may be fixed otherwise, my lord.
Item 10.
Item 10, my lord.
Any motion is left out.
My lord, yes, my lord. That is, my lord, regarding that, my lord, there is a parent department in, my lord, BSF, laterally absorbed in Arunachal Pradesh Police, my lord. Not in the, my lord, seniority list, my lord. A representation was made, my lord. Then a writ petition was filed, my lord. Or, my lord, may please to issue notice, my lord.
What has happened to this order?
My lord, here, my lord, impugned speaking order is there, my lord. That is, my lord, whereby, my lord, it is stated that during his absorption in the from the parent department, my lord, though inspector civil, my lord, the ex-cadre ward is there. Because of then, he is not, my lord, taken in the seniority list, my lord. Regarding that part, my lord, earlier, my lord, one representation was made, and because
that order page,
my lord, that is in page, my lord. It is, my lord, speaking order dated, my lord.
Page.
Yes, ma'am. My lord, 98 to 100, my lord. Page number 98, my lord. '98 is the speaking order, my lord, and Annexure 21, my lord.
Okay, Mr. K. Bashir and counsel for the petitioner. For state, you have Steve Angul and counsel appearing, government advocate appearing for all the respondents.
Yes, ma'am.
Next, the speaking order dated 27/9/2024 with the bracket annexure 21 bracket closed. Excluding the consideration of petitioner from the seniority list of regular cadre of inspector of APP within bracket civil bracket closed. Present revision has been filed under Article 226 of the Constitution of India, along with consequential reliefs. Issue notice returnable on, give a date after 4 weeks.
16.
So and so. Extra copies of the writ petition be served on the London government advocate within 2 days.
16. 16.
List on so and so.
My deeply obliged, my
can't be considered.
My lord,
It amount to granting of the full relief.
my lord, deeply obliged.
May I praise the lordship? I pray the item number 18. My lord, this is the second.
Those things she will take care of. Mr.
List of tomorrow.
Not tomorrow.
It's some urgency regarding this matter.
What is the urgency?
Some interim relief may be required.
See, what is the case? What
Case regarding
what is
the
urgency?
urgency, my lord. In the page number 25, annexure 6, it's clearly mentioned that some impugn order passed by the Deputy Commissioner of the CUME district.
What order is passed? Is it very difficult?
Yes, sir. This is the composition order regarding some portion of the properties, but not actual of the land. For that purpose, the authority directly encroached the each and every householders and took the forcefully to vacate the same without any giving me single penny. So it's very suffer, each and every day suffer lot of pressures and tortures. The Deputy Commissioner there force intends to do the same.
Not understood you.
Your Lordship, I'm appearing for respondent number 1 and 2, Your Lordship. In this case, they have filed an IA for implementation of the private party, Your Lordship. Since the private party was a necessary party, Your Lordship. On 7th November only, the IA was admitted, Your Lordship, and the implement was.
If you look about your urgency, see this page.
Yes, Your Lordship.
Show it this page. Yes, Mr. Pradhan.
Lordship, actually, my suspension has been extended without following the Supreme Court judgment and the rules made there.
Okay.
Very simple, short question of law.
Okay.
So it's possible, Your Lordship, tomorrow.
Especially. We already have a wrong list because
Your Honor, I am appealing for respondent number 5. I have to file a reply on it.
When?
Matter may be fixed on 24 this month. In the meantime, I will file the reply.
Item number. You're making two steps.
Item number
You said you have filed
seven-
again, then you said you are filing.
17.
What is right? You have filed or you have not filed?
Not filed yet.
You want to file a reply?
Yes. 17.
24th you want?
Yes.
24th of 11 November.
Yes.
Okay. Both sides are represented. Mr.
PK Gore.
PK Gore.
Gore. For respondent number 5.
Respondent number
5.
5. Praise that matter we listed on 24/11/2025, by which time he will file an affidavit in the matter.
My lord,
Here is allowed. List on 24/11/25.
Let him file before 24, Your Lordship. So if necessary, I shall also file my pleadings.
You send him advance copy by email.
Yes.
With advance copy by email to the Land Council for the petitioner. Filing, correct?
Yes.
Okay, others, please
My
take
lord,
the.
item 30, the date has to be fixed. My lord. Urgency is there because there is a stay in the tender matter.
Tell the.
I need a
tell
date
the-
on 3rd of
tell the
December.
Courtmaster.
My lord, in item 30, the interim order has to be extended, sir.
Just tell the Courtmaster. She'll do it because I have to go to.
My lord,
I have-
item number 22 and 23, my lord.
Item 13 was adjourned, Lordship, in the morning.
Huh?
It was adjourned, item 13. What 13? Okay.
Yeah, my lord, item number 22 and
You take care.
23. My lord, for tomorrow, my lord. Because only for issuance of notice, my lord. This is a review petition, my lord, by only your lordship can take the matter.
Okay.
Lordship,
How much delay is there?
No, delay has been conducted, my lord. Now in the review, my notice has to be go.
Okay, review issue notice.
Yes.
Mr. B. Picha for the petitioner.
Yes.
Returnable in 4 weeks. Steps within 2 days.
My lord.
Okay.
if I may please, Lordship, item number 27.
Tell her, we are not listing any matters tomorrow. Just tell her.
I'm leaving.